Hey, I made it. I am here. It is 4 p.m. Where I am. I did give you a warning that it might be to be ready. To be ready. I see here I have an invitation from Lynn Dalton about joining an exclusive interview with Saul Anderson, the brother of Zach. I will see if I have the opportunity to join that, but I have this damn cat that is I forgot to leave outside. Sorry about that. I don't know. Can you hear me? Hi, Roger. I am about 40 minutes behind on the stream from. Good morning, Billy. Good morning. Good morning, Sarah. Good morning, Roger. But let's go straight. We can hear you. You can hear me. Great. Let's go into this and see if you can. I don't have sound either from that, but it will show up eventually while I go. Sorry. I see the Michigan Law Show is on, starts at 8 p.m. my time. I will see, because as you see here, I will see if I can find the time to join that. I will send a message. I'll just. Yes, there is sound on the. Okay, so we are 40 minutes behind. I believe that.
He gets very animated too.
Sorry.
I'm going to call Allan Brown.
Oh, hang on, we need your clerk.
She's not going to be out here for the jury instruction.
Okay.
They are doing
State of Wisconsin versus
today they are
Allan Brown,
starting with,
21 CF 1344. Let's have the
closing
appearances,
arguments.
please.
Good morning,
And then
State Appearance
jury
by Alexander
instructions.
Smathers.
Allan Brown
And
appears
then
in
send
person
the
with
jury
attorneys
off
Addison Kuhn
for
Good morning. The
reaching a
jury
verdict,
is not in the
which I sadly
courtroom. We're
expect
going to do jury
to be a fast
instructions.
one.
I'm going to go through each instruction.
Good morning,
But I wanna
Deborah
start
from
out
SE
with
Southeast Ohio.
Page 6 of
Ohio,
the
I believe.
instructions, the statements of the defendant.
I will
And the
get
reason I bring
to
that up,
1.25, so you may
I went through the file, and I didn't see any documentation for
catching up.
anybody requesting any sort of hearing as to the statements of the defendant. I know they gave him his Miranda warnings. We know that. We know there's no written statement. I know the statements that he made to the deputy when he was in the hospital. She was there to guard him. She wasn't there to take any sort of statement or do any sort of interrogation. And those, obviously, I would consider spontaneous statements. She wasn't questioning him. He just on his own talked to the deputy, and I don't have a problem with that. But I'm looking at my notes, and that is Investigator Stephen Strom.
Hello, Suzanne
He was,
from California.
20, what is it?
Storm.
Storm, thank you. 23. And the attorneys can correct me, but my recollection is he went to talk to the defendant in the hospital, and he's an investigator. We know the defendant's in custody, and he did say that he did Miranda warnings, but there was a conversation that took place prior to that I have a problem with.
Oh,
And I believe the state asked the question, did he ask about whether there was a video or was this incident being recorded? And there was a back and forth conversation. I have a problem with those statements because we never had any sort of hearing, whether they were voluntary or whether there was a question asked. That's my issue with those statements. If you want to respond as to that, you can.
good morning, Aris.
Well, Your Honor, I do
Group.
think they were proper.
Group in
The
Arizona.
officer went there to, yes, to speak to the defendant. And before he could read him his Miranda rights, he, introduced himself, and the defendant began asking questions. And case law is clear, and I didn't research it.
I know case law, but here's the problem. That hearing as to those facts has to take place outside of the presence of the jury prior to the statements coming in.
If there's a challenge, and there never was.
It's automatic. It's not discretionary.
Oh, he is.
And case law is clear on that. They don't have to ask for it. And that's why sometimes when the state wants to use a statement, they'll tell the judge, wait a minute, even though the defense has not asked for one, we want a hearing on it.
Good call, Judge. Good call.
My solution, I'm going to strike all that testimony.
Okay.
Oh, Canada. Sorry,
And
Suzanne.
I'm going to tell the jury, just as to Stephen Storm, whatever conversations they had is all stricken from the record. Now, his other testimony as to what he testified as to, he prepared the drone and he took photos, that's totally different. But any actual conversation that they had, I'm going to strike.
Your Honor, it was actually Investigator Willis who interviewed the defendant, not Investigator Storm.
All right, then I stand corrected. Let me get to that, his notes. Wasn't he one of the last witnesses on day one?
Yes. And Investigator Storm was yesterday.
All right.
Your recollection of the testimony is correct. It's just the name of the witness.
I got the witness mixed up?
Mhm.
All right. Well, I got the important part right. Let me get to my notes. Is there any, the defense have an
I don't
objection to
think
me
it
striking
means
those statements?
Much.
No, that's fine.
Yeah, I'm going to, that's the first thing I'm going to tell the
I'm
jury
on
when they come
early,
out.
Broken Baker.
That is only as to that witness.
Set up in the description that I would hurry back and
Oh, here we
the
go.
stream would
Andrew Willis,
begin at any time before 2.
investigator.
But
So you're telling me that's the
Well-
officer to talk to the defendant in the hospital?
Yes.
they are not up onto the closing arguments yet. It is an issue with testimony
Okay,
between
let's,
Allan Brown and an investigator
Order then, since we
when
have
he
that,
wasn't
completed. And then for
Miranda
Ms. Mathers, I have a,
Brandeised.
the stricken instruction is like one line. I
Okay.
just printed it off. You don't have to reprint all your instructions, and I'll just read it.
Okay. Thank you.
So
So, all right, let's start out with the jury instruction, and I'll ask the defense.
instructions.
Any objection to the instructions? And I'll go through each one.
The judge
Any objection
strike
to the
a bit
opening
from
instructions?
one
Any objections to reading evidence?
testimonies.
Any objections to
tiny
reading
bit,
circumstantial
because,
evidence?
Mr. Allan
Any
Brown
objection
was
to
not
reading
properly
information, not evidence?
Mirandized.
Any objection to weight of the evidence? Jurors' knowledge?
Defense didn't
Exhibits.
have to object to it
Transcripts not available for
because
deliberations?
it is automatic.
Police reports?
No.
as
Objections,
I
evidence
interpreted
received
it.
over objections?
No.
So now we
Remarks
are
of counsel.
reading
No.
Closing
instructions?
arguments of counsel?
No.
Expert opinion testimony general?
I guess I don't know that. Did we qualify anyone as an expert in the case?
I think we had the doctor
And crime lab
and the
analyst.
crime lab.
That's fine. Yeah.
I would consider those experts because they gave opinions.
That's fine.
Credibility of witnesses?
No.
Statements of the defendant?
No.
Defendant elects not to testify?
No.
Evidence of other conduct?
No.
One defendant, 9 counts?
No.
Did you go over each count?
I did. Yes.
Right. Do we have the dates and correctly from the state?
Yes.
Jesus Christ. I have my cat with me, and he is scratching my leg. I don't think I have to send. I think everything is.
Right, then we're up to burden of proof, presumption of innocence. Any objection?
No.
Verdict submitted for one defendant, multiple counts, separate verdict on each count. Any objection to that?
No.
Any objection to closing instructions?
No.
Unanimous verdict selection of presiding juror?
No.
And has the defense looked at all the verdict forms?
I did. Yes.
All channels
objection
can
to the
redirect
verdict
to
forms?
my content.
Any other instructions that the defense wishes the court to read to the jury?
No, I don't. believe
Any
so.
other instructions that the prosecution wishes the court to read to the jury?
No, Your Honor.
All right. Any idea how long your closing is going to go, Ms. Mathers?
20 minutes.
Any idea how long your closing is going to go?
It's about 3.5.
I didn't hear you.
About 3.5 minutes.
All right. And then you're going to do a rebuttal?
Briefly.
Okay. I have to read my instructions. It's probably going to take longer than anything. And then we'll try to get everything done and let them start deliberating. And again, we'll bring in lunch for the jury. Anything else we need to address before we take a short break?
I just want to make sure the verdict forms you have, Your Honor, have the correct year.
Okay, let me, and what, as to the date, dated?
Yes, all the verdict forms originally I had March 2022. Attorney Kuhn pointed that out. I fixed it and resent it to your
Let me
clerk.
go through each one here.
Sorry for not talking much, but I am trying to.
All right, you all have 2023.
Excellent. Thank you.
All right, we can take a short break and we'll
I
wait for the
sent
jury to
a
show up.
link to my stream to Vice's through Twitter. I will send him an invite to the stream as well, if he chooses to join me, but it's very, very late there. But it's not too late for Chandler, if she chooses. Please don't, because since we are not up to speed, don't spoil anything in the chat if you would be nice, because I have not seen anything yet. Yeah. Cheers, Fiery Red. Welcome. Let's see if we can skip ahead a bit. Break. There's a break. Which would move us in a lot closer. There. Good morning, Mandy. Welcome. And Papa G from Growers Low from Saskatchewan. Sorry for butchering the pronunciation. KT from Illinois, 70 miles southwest of this court. And this person will, in a while, go to Illinois, I believe, for the second trial, the alleged Midwest killing spree. Yeah, yeah, I'm trying. Oh, that was bad. I will not make Elaine references. We are all sick of that.
We're going
Maybe.
to go on the record on Allan M. Brown, 21 CF 1344. Let's have the appearances, please.
Good morning. State appears by Alexander Smathers.
Allan Brown appears in person with attorney Addison Kuhn and McKenna Quinton.
Good morning. The jury is back in the courtroom. Thank you for coming on time this morning,
I
ladies and
still
gentlemen.
don't know that.
Before we do our
name because
jury
you know,
instructions and closing arguments, I want you to know that I am going to strike some testimony. And if you remember from voir dire on Monday, you took an oath and you promised to listen to the evidence, listen to my jury instructions. This
Yes,
testimony that I'm striking
This is for
is
the
from
things he did in Wisconsin.
Tuesday, May 28th. It was late in the afternoon.
Carjacking allegedly.
There's an investigator from the same
And
sheriff's
he will
department,
be
Andrew
moved
Willis,
to Illinois,
testified
where he
that he went to the
allegedly
hospital and he talked to the defendant
did,
for a very short
double
period of
homicide.
time, and there was a conversation. So any testimony as to that conversation between the investigator and the defendant, I am striking.
Oh,
and you will
thank you,
not
Papa G.
consider. I will read the jury instruction to you right now. I'll repeat it later on, but stricken testimony means during a trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. So I'm ordering you not to consider that testimony, that conversation between that investigator and the defendant. Okay, with that, I'm going to read my instructions.
I
You'll
am
have
at
a hard copy when you go in the
speed,
back. I have
so
to read the
and we are
instructions
at
to
the
you.
moment
Once
just
I'm done
6
with my
minutes behind.
instructions, the attorneys will do their
Law
closing
and crime
arguments.
stream.
And because the state has the burden of proof, they get to talk once. I'm sorry, they get to talk twice. The defendant only gets to talk once, so you understand what's going on. So with that, and we don't have any pads or pencils, right? Nobody's got their pads. Give them to the bailiff. You'll get your pads back later, but you can't have them during closing, okay? Thank you. All right, members of the jury, the court will now instruct you about the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all these instructions. Regardless of any opinion you may have about the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply the law to the facts in the case which has been properly proven by the evidence. Consider only the evidence received during this trial, and the law is given to you by these instructions. And from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of facts solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. Evidence. Evidence is first the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Circumstantial evidence. It's not necessary that every fact be proved directly by a witness or an exhibit. The fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt.
He's not the
defendant committed the
cuddliest
offense
cat
before
in the
he
world,
may
no.
find the defendant guilty. Information, not evidence. And information is nothing
agree,
more than a
but
written formal accusation against
they
the defendant
they
charging the
showed
commission
a dog
of one or more
jury.
criminal acts. You are not to consider it as evidence
That
against
it
the
was
defendant in
really,
any way.
really damning.
It does not raise any inference of guilt. The weight of the evidence. The weight of the evidence does not depend on a number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness or even several other witnesses. Jurors' knowledge. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. Exhibits. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Transcripts not available for deliberations. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. As such, you should pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and the testimony introduced during the trial. Police reports. During the course of a trial, the attorneys may refer to or use police reports with witnesses. Normally, these police reports will not be provided to you. If you are not provided with a police report, you should use your collective memory regarding any reference to the police reports. Objections. Evidence received over objections. Attorneys for each side have the right and a duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, the jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Remarks of counsel are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. Closing arguments of counsel. Consider carefully the closing arguments of the attorneys, but their arguments are conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. Expert opinion, testimony, general. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give the opinion, you should consider the qualifications and the credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion.
There was one
Opinion
objection,
evidence was received to help you reach a
a
conclusion.
compound
However, you are
objection
not
on
bound by any
the
witness's
second to last
opinion.
witness,
The credibility of
who was
witnesses
only there
is the duty
to.
of the jury to scrutinize and to
We
weigh the
will
testimony of
watch
witnesses
that
and to determine the
as
effect of the
soon as
evidence
they
as a whole.
send off
You are the
the
sole
jury.
judges of the
We will
credibility,
do the
that
last
is, the
hour
believability of the
of
witnesses
yesterday's
and the weight to
stream,
be given to their
which
testimony.
I missed out
To
on.
determine the credibility of each witness and the weight you give to the
So
testimony
there
of
was
each witness.
one.
Consider
I
these
have
factors.
opinions on
Whether the witness had an interest or
podcast.
lack of interest in the result of this trial. The witness's conduct, appearance, and demeanor on the witness stand. The clearness or lack of clearness of the witness's recollections. The opportunity the witness had for observing and for knowing the matters the witness testified about. The reasonableness of the witness's testimony. The apparent intelligence of the witness. Bias or prejudice, if any, has been shown.
Yeah, it
Possible
was
motives for
too obvious
falsifying
even for
testimony.
this defense.
And all other facts and
But
circumstances
it was
during the trial,
overruled.
which
So
tend either to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There's no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourself the reliability of things people say to you. You should do the same thing here. Statements of the defendant. The state has introduced
yes,
evidence of
Broken
statements
Baker,
which
I have
claims were made
the
by the defendant.
article.
It is for you to determine how much weight, if any, to give to each statement.
I think.
In evaluating each statement, you must determine three things: whether the statement was actually made by the defendant, or only so much of a statement as was actually made by a person may be considered as evidence, whether the statement was actually reinstated here at trial, whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence, and determine how much weight, if any, the statements deserve. Defendant elects not to testify. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Evidence of other conduct. Evidence has been presented regarding other conduct of the defendant for which the defendant is not on trial. Specifically, evidence has been presented that the defendant was involved in 2 homicides in Chicago, Illinois in the early morning hours of October 21st, 2021. You should only consider this conduct for the purpose of context or background, that is, to provide a more complete presentations of the evidence relating to the offenses charged. You may not consider this evidence to conclude that the defendant has certain character or a certain character trait, and that the defendant acted in conformity with that trait or character with respect to the offense charged in this case. You may consider this evidence only for the purpose I have described, given it the weight you determine it deserves. It is not to be used or conclude that the defendant is a bad person or for that reason is guilty of the offenses charged. One defendant, there's 9 counts. Count 1, first-degree reckless endangering safety by use of a dangerous weapon. The first count of the information charges at Allan
Hi, Amanda. Welcome.
on or about Thursday, October 21st, 2021, in the village of Bristol, County Kenosha, the state of Wisconsin. Dick recklessly endangered the safety of Juan D. Avila under circumstances which show utter disregard for human life, contrary to section 941.30 sub 1, 939.63 sub 1b of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. The statutory definition of the crime. First degree reckless endangering safety, as defined in 941.30 sub 1 of the Wisconsin Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. The state's burden of proof before you may find a defendant guilty of first-degree reckless endangering safety, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present. The elements of the crime the state must prove. Number 1, the defendant endangered the safety of another human being, Juan D. Avila. 2, the defendant endangered the safety of Juan D. Avila by criminally reckless conduct. Criminally reckless conduct means conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury, which creates a substantial risk of
now
death,
is the jury
which causes serious permanent disfigurement,
make that
which
clear
causes a
for anyone
permanent or
new
protracted
incoming,
loss or impairment of the function of any bodily member or organ
or
or other serious bodily injury.
4
The
minutes.
circumstances of the defendant's conduct
Law and
showed
Crime
other
Street.
disregard for human life. In determining whether the circumstances of the conduct showed other disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life,
Anton.
and all the facts and circumstances relating to the conduct. Consider also the defendant's conduct after the alleged act to have endangered safety to the extent that it helps you decide whether or not the circumstances showed other disregard for human life at the time the act alleged to have endangered safety occurred. The jury's decision. If you are satisfied beyond a reasonable doubt that all 3 elements of this offense are present, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 1 of the information alleges not only that the defendant committed the crime of first-degree reckless endangering safety,
What happened
but
was
also
I
that the
put my
defendant did so
stream up
while
at
using a
6
dangerous
p.m.
weapon.
my time.
If you find the
Because
defendant guilty,
I
you
had a
must answer the
last-minute
following
appointment
question.
I had to go
Did the
to,
defendant use a
and
dangerous weapon in committing this crime?
so I gave
Dangerous
a full
weapon means
warning
any
in
firearm,
the
whether loaded or unloaded. A
below
firearm is a weapon that
that
acts by
I
force
might
of
get
gunpowder.
the
Before you
stream
may
going
answer
early.
this question, yes, you must be satisfied beyond a reasonable doubt that the
So
defendant
we're
committed the crime while using a dangerous weapon. If you are not so satisfied, you must
not
answer
much
the
happened.
question no.
This is just the jury
Count
instructions.
2, first-degree reckless endangering safety by use of a dangerous weapon.
But
The second count
the
of
judge
the
did
information
strike a
charges that
part
Allan
of
M.
a
Brown
testimony
on or about Thursday, October 21st,
because the
2021,
defendant
in the
was not
village of Bristol, the county
Mirandized
Kenosha, the state of Wisconsin.
before he
Dick
started
recklessly
before
endangered the safety of Allan
an
Courtroom
alleged
under
interview.
circumstances which showed other
What's
disregard
that
for
mark
human
on
life,
his face?
contrary to section 941.30 sub 1,
You see that?
939.63 sub
What
1b
happened?
of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the
What
offense charge
is
beyond
those
a
marks
reasonable
weren't there
doubt.
yesterday?
Statutory definition
Were they?
of the crime. First-degree reckless endangering safety, as defined in 941.30 sub
Huh.
1 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show other disregard for human life. Before you may find a defendant guilty of first-degree reckless endangering safety, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. The elements of the crime that the state must prove. Number one, the defendant endangered the safety of another human being, Colin Coultrip. The defendant endangered the safety of Colin Coultrip by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial. The defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. The circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for human life, and all other facts and circumstances relating to the conduct. Consider also the defendant's conduct after the act alleged to have endangered safety to the extent that it helps you decide whether or not the circumstances show utter disregard for human life at the time the act alleged to have endangered safety occurred. The jury's decision. If you are satisfied beyond a reasonable doubt that all three elements of this offense were present, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 2, the information alleges not only that the defendant committed the crime of first-degree reckless endangering safety, but also that the defendant did so while using a dangerous weapon. If you find the defendant guilty, you must answer the following question. Did the defendant use a dangerous weapon in committing this crime? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by force of gunpowder. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt
Don't know.
that the defendant committed a crime.
Nothing that has
while
been
using
brought
a
forward
dangerous
by
weapon.
anyone.
If you're not so satisfied, you must answer the question no. Count 3 of the information. First-degree reckless endangering safety by use of a dangerous weapon. The third count of the information charges that Allan M. Brown, on or about Thursday, October 21st, 2021, in the village of Bristol, the county Kenosha, the state of Wisconsin, did recklessly endanger the safety of Terry Tiff under circumstances which showed utter disregard for human life, contrary to section 941.30 sub 1, 939.63 sub 1b of the Wisconsin statutes.
There's a few more joining us.
For this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. The statutory definition of the crime: first-degree reckless endangering safety, as defined in 941.30 sub 1 of the Wisconsin Criminal Code, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. State's burden of proof. For you may find a defendant guilty of first-degree reckless endangering safety. State must prove by evidence which satisfies you beyond a reasonable doubt the following three elements were present. The elements of the crime the state must prove. Number one, the defendant endangered the safety of another human being, Terry Tiff. 2, the defendant endangered the safety of Terry Tiff by criminally reckless conduct. Criminally reckless conduct means conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial. The defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent and protracted loss or impairment of the functions of any bodily member or organ or other serious bodily injury.
Case in chief yesterday, and the defense chose to not adopt case in chief.
In determining whether circumstances of the conduct showed other disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. Consider also the defendant's conduct after the act alleged to have endangered safety, to the extent that it helps you decide whether or not the circumstances showed other disregard for human life at the time the act alleged to have endangered safety occurred.
Closing
The
arguments.
jury's decision.
So probably
If you're
they chose
satisfied
to
beyond
do the
reasonable
jury
doubt that all
instruction
three
before
elements of this offense are
closing
present, you
arguments.
should find the defendant
Unless
guilty.
I missed out on
If you are not so
something
satisfied,
severely
you must
yesterday,
find the
but I don't
defendant
think
not
so.
guilty. Count 3 of the information
last
alleges
thing
not
I
only
heard
that the
from
defendant
yesterday
committed
was
a crime
that
of first degree
they
reckless endangering safety, but also
ended
that the
their
defendant
case.
did so while using a dangerous weapon. If you find the defendant guilty, you must answer the following question. Did the defendant use a dangerous weapon in committing this crime? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by force of gunpowder. Before you may answer this question, yes.
If
you must be
anyone have any
satisfied
information
beyond a
about
reasonable doubt the defendant
they
committed
have
the
in their
crime
closing
while using a
argument
dangerous weapon.
yesterday,
If you're not so
please do
satisfied,
so.
you must answer the question.
But we will find out
Count
soon enough
4,
here.
possession of a firearm. The fourth count of the information charges an Allan M. Brown
We are 2
on or
minutes
about
now in
Thursday,
the
October 21st,
law
2021,
and
Village of
time,
Bristol, the County Kenosha,
stream.
State of Wisconsin, did possess a firearm, having been convicted of a crime
Okay,
elsewhere
closing
that
arguments
would
are
be a
coming up.
felony if committed in this state, contrary to section 941.29 1MB of the Wisconsin statutes.
Okay,
For this
I will
charge,
leave
the
you
defendant
to
essentially pleaded
watch
not
this
guilty,
while I
which means the
brew
state must
myself
prove
a cup
every
of
element
coffee.
of the offense
Okay,
charge
see
beyond
you
a
in
reasonable doubt.
2 minutes.
Statutory definition of the crime. Section 941.29 sub 1M of the Criminal Code of Wisconsin is violated by a person who possesses a firearm if that person has been convicted of a felony. The state's burden of proof. Before you may find a defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements are present. The elements of the crime that the state must prove. Number one, the defendant possessed a firearm. Firearm means a weapon which acts by force of gunpowder. It's not necessary that the firearm was loaded or capable of being fired. Possessed means that the defendant not only had actual physical control of a firearm. It's not required that a person own an item in order to possess it. What is required is that the person exercise control over the item. The defendant had been convicted of a felony before October 21st, 2021. The parties have agreed that the defendant was convicted of a felony before October 21st, 2021, and you must accept this as conclusively proved. The jury's decision. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 5, harassment of police animals. Fifth count of the information charges that Allan M. Brown, on or about Thursday, October 21st, 2021, in the Village of Bristol, the County Kenosha, the State of Wisconsin, did intentionally strike an animal by using a dangerous weapon. Knowing that that animal is the victim is used by law enforcement agencies to perform agency functions or duties and cause injury to that animal, contrary to section 951.182M of the Wisconsin statutes, and contrary to section 951.0951C of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. Statutory definition of the crime. Section 951.095 and 951.182M of the Criminal Code of Wisconsin are violated by one who causes injury to an animal that is used by law enforcement agency to perform agency functions by intentionally striking, shoving, kicking, or otherwise subjecting the animal to physical contact, and knows that the animal is used by law enforcement agency to perform agency functions. State's burden of proof, or you may find the defendant guilty of this offense. The state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. The elements of the crime that the state must prove. Number one, canine Riggs was an animal used by law enforcement agency to perform agency functions. Number two, the defendant knew that the animal was used by law enforcement agency to perform agency functions.
If it is
the defendant
more
intentionally
than an
struck,
hour
shoved, kicked, or otherwise subjected the animal
I
to
think they will
physical
be back
contact.
before lunch.
Striking, shoving,
If it's
kicking, or
closer
otherwise
to lunch,
subjecting the
I
animal
think they
to
will
physical
choose to
contact
have
cause
lunch
injury to the
before
animal.
they turn
The
the
jury's
papers.
decision. If you're satisfied beyond a reasonable
Now,
doubt
there
that all
is
four
a
elements
slimmer
of this
of
offense have
chance
been proved,
that the
you should
jury
find the defendant
just
guilty.
found
If you are
these
not so
officers
satisfied, you must find
unreliable.
the defendant not guilty.
I
Count 6,
don't know how
mistreating an
I
animal,
would,
use of a dangerous weapon. The
but
sixth count of the information charges that Allan M. Brown, on or about
we have
Thursday,
been
October
surprised.
21st, 2021, in the Village of
The
Bristol,
last
County
few
Kenosha,
trials
State of
we
Wisconsin,
watched.
did intentionally
Allan
treat in a
Quinn.
cruel manner an
You
animal,
never know.
canine Riggs, he knew was being used by law enforcement agency to perform agency functions or duties causing injury to that animal,
If you
contrary to
had a
section
deal on the table,
951.02 of the
I don't know
Wisconsin
why
statutes,
he,
and
with this
contrary to
kind of defense, I don't know why.
930.631C of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The statutory definition of the crime: mistreating an animal, as defined in 951.02 and 951.18 of the Criminal Code of Wisconsin, is committed by one who intentionally treats an animal in a cruel manner. State's burden of proof: before you may find a defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. The elements of the crime the state must prove: number one, the defendant treated an animal, canine rigs, in a cruel manner. Cruel means causing unnecessary and excessive pain or suffering, or unjustifiable injury or death. Number two, the defendant intentionally treated canine rigs in a cruel manner. Intentionally requires that the defendant acted with the mental purpose to treat the animal in a cruel manner, or was aware that the conduct was practically certain to cause that result. The jury's decision: if you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant intentionally treated an animal in a cruel manner, you must answer the following question: did the defendant cause injury to that animal and know that that animal was used by law enforcement agency to perform agency functions or duties? Before you may answer this question yes, you must be satisfied beyond a reasonable doubt that the answer to that question is yes. If you are not so satisfied, you must answer the question no. Count 6 of the information alleges not only that the defendant committed the crime of mistreating an animal, but also the defendant did so while using a dangerous weapon. If you find a defendant guilty, you must answer the following question: did the defendant use a dangerous weapon in committing this crime? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by force of gunpowder.
They should be, but
Before you may answer
this
this
is how
question,
we
yes, you must be
reason
satisfied
to look
beyond a
from the
reasonable doubt
outside
that the
in.
defendant committed the
We
crime
have,
while using
we
a
have
dangerous
discussed
weapon.
it with each
If you're not so
other.
satisfied, you must answer the
We have
question
brought
no.
forward
Count
theories.
7, failure to
We
comply
have-
with an officer's
doesn't
attempt
have
to take a
what we have
person
here.
into custody. The seventh count of the information
And
charges that Allan M. Brown, on or about Thursday, October 21st,
I'm still planning to
2021,
do a
in the
mock
village of Bristol, the county of
defense
Kenosha,
closing
did intentionally refuse to
on
comply with
this
an officer's
trial.
lawful attempt to take him or her
That will
into custody,
probably be a
and
video
retreats or
that
remains
goes
in a
up
building or
tomorrow.
place, and through action or threat attempted to
So we
prevent
will
the officer
see.
from taking him
I
or
think
her
I have
into custody while doing
that
each of the
closing or
above.
mock
Remain or
argument
become armed with a
planning
dangerous weapon,
also
or threaten to use a
includes
dangerous
me
weapon, regardless of
bringing
whether
in
he had a
some
dangerous
evidence
weapon.
to this defense.
Contrary to section
Yes.
946.15 sub 2 of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The statutory definition of crime,
I agree. That might
946.415
very
of
well
the
be
Criminal Code
so,
of
but
Wisconsin, is violated by a
again,
person
they
who
can't
intentionally does
avoid
all the following:
protecting
refuses
his
to comply
constitutional
with the
right
officer's lawful attempt
by
to take the person
objecting
into
to
custody, retreats or remains in a building or
to
place, and through action or threat attempts to prevent
irrelevance
the
and
officer
stuff
from
like
taking
that.
the person into custody, and remains or becomes armed with a dangerous weapon or threatens to use a dangerous weapon, regardless of whether the person
Might
had
be.
a dangerous weapon. The state's burden of proof: before you may find a defendant guilty of this offense, the
Beefy!
state must prove by evidence which
Welcome.
satisfies you beyond a reasonable doubt that the following three elements are present.
No,
The elements
so
of the crime the
it's
state
just
must
jury
prove: number one,
instructions, and
the defendant
judge,
intentionally refused to comply with the
struck
officer's
down on
lawful attempt to take
one
the defendant
testimony
into custody.
because
Intentionally requires the defendant knew that an officer was
properly,
lawfully attempting to take the defendant into custody.
during that
Number
interview.
two, the defendant intentionally retreated or remained in a building or place and through action or threat intentionally attempted to prevent the officer from taking the defendant into custody. Number three, while committing elements 1 and 2, the defendant intentionally remained or became armed with a dangerous weapon. Deciding about intent and knowledge. You cannot look into a person's mind to find intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, or statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge.
And we
The
are
juror's
up to
decision:
speed.
if you are
We
satisfied
are
beyond a
live
reasonable doubt
with
that all three
law
elements of
and
this offense
order.
have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 8, driving or operating a vehicle without the owner's consent, use of a dangerous weapon. The 8th count of the information charges at Allan M. Brown on or about Thursday, October 21st, 2021, in the village of Bristol, the county Kenosha, the state of
Don't
Wisconsin,
forget to
did
like
intentionally
and
drive
subscribe,
or operate
please,
a
folks.
vehicle, a
I know
2016
you're very,
Buick
very good at it.
Encore, without consent to the owner,
I would not
Miguel
mind.
Padilla Jr., during the carjacking of this
We
vehicle,
are,
contrary to section
I believe, 38
948.23
current
sub
viewers,
3,
and I have
930
only 29 likes.
Kenosha, the state of Wisconsin, did intentionally drive or operate a vehicle, a 2016 Buick Encore, without consent to the owner, Miguel Padilla
They have
Jr.,
everything on paper.
during the
They will
carjacking
have
of
these
this vehicle,
instructions sent in
contrary
with
to
them.
section 948.23 sub 3 and 939.63 1C of the Wisconsin statutes. To this charge, the defendant has entered a plea of not
They
guilty,
stated it
which means the
as a
state must
fact.
prove every element of the offense
That
charge
was
beyond a reasonable
entry,
doubt.
and the other one.
Statutory definition of the crime: driving or operating a vehicle without owner's consent, as defined in 943 sub 23 sub 3 of the Criminal Code of Wisconsin, is committed by one who
the
intentionally drives or
Chicago
operates a
officers
vehicle
that
without
testified
consent to the owner.
yesterday
The
brought
state's
that
burden
up.
of proof before you may find the defendant guilty of this offense, the
Well,
state must
41
prove
likes
by
on it.
evidence which satisfies you beyond a reasonable doubt that the following two elements were present. The elements of the crime the state must prove: number one, the defendant intentionally drove or operated a vehicle.
Oh, I have
without
43
consent
likes.
of the owner.
Oh,
Drive
thank you.
means
I have
to
more likes
exercise
than
physical
fewer.
control over the speed and direction of a vehicle while it is in motion. Operate means that the physical manipulation or
It seems to
activation of
increase a
any
bit
of the
now.
controls
Hopefully,
of
we
a
will
vehicle
go
is
up
necessary
towards where we
to
were
put it
yesterday
into motion.
during the stream, where
Defendant
we
knew that the owner of
were
the vehicle did not consent to the driving
70
or
to
operating the
80
vehicle.
at one time.
Deciding about intent and knowledge. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge
That's a
must
very
be
good ratio.
found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in his case bearing upon intent and knowledge.
Yeah, the likes
Jury's decision.
on the updates.
If you're satisfied
refresh
beyond a
the page.
reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 8 of the information alleges not only that the defendant committed the crime of drive or operate a vehicle without owner's consent, but also the defendant did so while possessing a dangerous weapon. If you find the defendant guilty, you must answer the following question: did the defendant possess a dangerous weapon while committing this crime? Dangerous weapons means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by force of gunpowder. Or you may answer this question: yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while possessing a dangerous weapon. If you're not so satisfied, you must answer the question no. Count 9, attempted escape from custody resulting from legal arrest for a crime. The 9th count in the information charges at Allan M. Brown on or about Friday, October 29th, 2021, village of Pleasant Prairie, the county Kenosha, the state of Wisconsin, attempted to intentionally escape from custody, having been lawfully arrested for a crime contrary to section 946.42 sub 3A and 939.32 of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt.
To be fair,
Statutory
it's not really
definition of the
interesting
crime.
yet. So
The crime of attempted escape from custody is defined in
when people see that the
939.32
closing arguments
and
is on.
946.42 sub 3 of the Criminal Code of Wisconsin is committed by a person who, with intent to commit escape from custody, does acts towards the commission of that crime which demonstrate unequivocally under all the circumstances that he has formed that intent and would have committed the crime except for the intervention of another person or some other extraneous factor. State's burden of proof. Before you may find a defendant guilty of
Not
this
impossible.
offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements are present. The elements of the crime the state must prove. Number one, the first element of attempted escape from custody requires that the defendant intended to commit the crime of escape from custody.
Hello, Joe. Welcome.
The crime of
Yeah,
escape
he's
from custody is
Probably
committed
putting
by
up a
one
better
who
defense than the defense
intentionally
as well by
escapes
just
from
reading the
custody
jury
when that
instructions.
custody resulted from a legal arrest for a crime. The elements of escape from custody are as follows.
Hi,
Number one,
Samuel.
the defendant was in custody. Custody means the physical
the
control of
defense
a person
made a
by a peace
32-second
officer.
opening
A person
argument.
also is in custody when
They
temporarily
objected
outside of
only
an
once.
institution for
That was to
purposes
the
of
second to
receiving
last
medical
witness,
care.
or the last
Number
witness.
two, the
They
custody
sought
resulted
a
from a
grand
legal
total
arrest for
during
a
2
crime.
days and
An arrest
12
for
or
a crime
13
is legal
witnesses,
when the officer making the arrest
maybe
has reasonable
30
grounds to believe
questions.
that person is committing
And
or
they
has
did not
committed
put up
a
a
crime.
case
First
in
degree
chief.
reckless endangering safety, possession of a firearm
So
by an out-of-state felon,
that and
harassment of
the
a police
prosecution
animal,
showed the
mistreatment
dog
of an
who was
animal,
shot
failure
and
to
survived
comply with
the
the
jury.
officer's duty to
So
take into custody and drive or
I
operate a
would be
motor vehicle
extremely surprised
without owner's
if the jury
consent
comes
are
back
all
with
crimes.
anything else
The
than
defendant
guilty on all
escaped from
counts.
custody. Escapes means to leave in any manner
Thank
without
you so
lawful
much, Didi.
permission or
Thank you
authority.
so much.
The escape from custody was
I will see if
intentional.
I have a
This
update
requires that the defendant
on-
intentionally escape from custody. That is, that the defendant had the mental purpose to escape. The crime charge of the
I don't
defendant in this
have
case, however,
an
is not
update
escape
on
from
how many
custody
watch
as
hours I
defined,
have.
but
It
an
hasn't been
attempt to
updated
commit the
since
crime
tomorrow.
of escape from custody. The second element of attempted escape from custody requires the defendant did acts towards the commission of the crime of escape
It hasn't
from custody,
updated
which
since yesterday,
demonstrates unequivocally
so I'm 3
under
days
all the
behind on
circumstances that the defendant
watch
intended
hours,
to
which
and would
means
have
more or less
committed the
the
crime of
entirety of
escape
my
from
streams
custody,
from this trial
except
is
for
not
the
in my
intervention of
watch
another
hour
person
count.
or some other extraneous factor, meaning unequivocally. Unequivocally means that no other inference or conclusion can reasonably or fairly be drawn from the defendant's acts under the circumstances. Meaning of another person. Another person means anyone but the defendant and may include the intended victim. Meaning of an extraneous factor. An extraneous factor is something
I
outside
hope
the
so,
knowledge of the
but
defendant or
I
outside
remember
the
that
defendant's
from my
control.
1,000
Deciding about
subscriber
intent.
stream, that took
You
almost
cannot
a
look
week
into a
for
person's
all
mind to
the
find intent.
watch
Intent must
hours
be
to
found and
enter.
found at all from all the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. The jury's decision. If you are satisfied beyond a reasonable doubt that all the elements of the attempted escape from custody have been proved, you should find
I
the
don't know
defendant
what happened
guilty.
to him.
If you are not so satisfied, you must find the defendant not guilty. Burden of proof and a presumption of innocence. In reaching your verdict, examine the evidence with care and caution, act with judgment, reason, and prudence. Presumption of innocence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The state's burden of proof. The burden of establishing every fact necessary to constitute guilt is upon
He
the
asked a
state.
few questions, but
Before
not
you can
the-
return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. Reasonable hypothesis. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocent, you should do so and return a verdict of not guilty. The meaning of reasonable doubt. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt it would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from a fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Verdict submitted for one defendant, multiple counts, separate verdict on each count required. The following forms of verdict will be submitted to you concerning the charges against the defendant, Allan M. Brown. Count one reading. We, the jury, find the defendant, Allan M. Brown, not guilty of first-degree reckless endangering safety, to wit, Juan Avila,
True.
is charged in count
I
one.
agree with you, Amanda.
Another reading. We, the jury, find the defendant, Allan M. Brown, guilty of first-degree reckless endangering safety, to wit, Juan Avila, is charged in count one of the information. Please answer the following question.
Yeah.
Did the defendant use a dangerous weapon in
Everyone
committing
deserves
this
a decent
crime?
defense,
Yes or no,
especially
mark one. Count two.
people
One reading. We, the
that
jury,
are
find the defendant,
alleged
Allan M.
to
Brown,
committed
not guilty of
these,
first-degree reckless
not only
endangering
these crimes,
safety,
but the
to
alleged
wit,
crimes
Colin Coltrip,
claim he
is
committed
charged
in
in count two of
Illinois.
the information. Another reading. We, the jury, find the defendant,
If he
Allan
is convicted
M.
here,
Brown,
the case in
guilty of first-degree reckless
Illinois
endangering
will become
safety, to wit,
so much
Colin Coltrip,
easier when they
charged
can
in
show
count two
that while he was trying to
information.
escape from Illinois, he shot a police dog.
Please answer
Imagine
the
that.
following question. Did the defendant use a dangerous weapon in committing this crime? Yes or no? Check one. Count three. One
There
reading.
are
We, the jury,
a few
find the
holes
defendant, Allan M.
that
Brown,
could be
not
poked
guilty of
into.
first-degree reckless endangering safety, to wit,
I will
Terry
make a
Tiff,
video, a
is
mock
charged in count
defense
three of the
closing, where I
information.
will bring up
Another
some of that,
reading.
which I
We, the
doubt
jury,
his
find the defendant,
current
Allan
defense
M.
will.
Brown, guilty of first-degree reckless
But
endangering safety, to wit, Terry Tiff, is charged in
yeah,
count three of the
I'm
information.
not so
Please
sure.
answer the following question. Did the defendant use a
Without
dangerous
discussing
weapon in
it with
committing this
anyone,
crime?
just
Yes or
watching
no?
the trial,
Check
I'm
one.
not sure I
Count
would have
four.
found
One reading. We, the jury,
not
find the
guilty
defendant, Allan
verdict.
M. Brown, not guilty of possession of a firearm, is charged in count four of the information. Another reading.
Unless
We, the
proven
jury,
guilty.
find the
Yes, I
defendant,
agree.
Allan M. Brown, guilty of possession of a firearm, is charged in count four of the information. Count five. One reading. We, the jury, find the defendant, Allan M. Brown, not guilty of a harassment of police animals, is charged in count five of the information. Another reading. We, the jury, find the defendant, Allan M. Brown, guilty of harassment of police animals, is charged in count five of the information. Count six. One reading. We, the jury, find the defendant, Allan M. Brown, not guilty of mistreating an animal, is charged in count six of the information. Another reading. We, the jury, find the defendant, Allan M. Brown, guilty of mistreating an animal, is charged in count six of the information. Please answer the following question. Did the defendant cause injury to the animal and know that the animal was used by a law enforcement agency to perform agency functions or duties? Yes or no? Check one. Did the defendant use a dangerous weapon in committing this crime? Yes or no? Check one. Count seven. We, the jury, find the defendant, Allan M. Brown, not guilty of failure to comply with an officer's attempt to take a person into custody, as charged in count seven of the information. Another reading. We, the jury, find the defendant, Allan M. Brown, guilty of failure to comply with an officer's attempt to take a person into custody, as charged in count seven of the information. Count eight. One reading. We, the jury, find the defendant, Allan M. Brown, not guilty of driving or operating a vehicle without owner's consent, as charged in count eight of the information. Another reading. We, the jury, find the defendant, Allan M. Brown, guilty of driving or operating a vehicle without owner's consent, as charged in count eight of the information. Please answer the following question. Did the defendant possess a dangerous weapon while committing this crime? Yes or no? Check 1. Count 9. One reading, we the jury find the defendant Allan M. Brown not guilty of attempted escape from custody as charged in count 9 of the information. Another reading, we the jury find the defendant Allan M. Brown guilty of attempted escape from custody as charged in count 9 of the information. It is for you to determine whether the defendant is guilty or not guilty of each offense charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charge in one count must not affect your verdict on any other count. I'm going to read to you again the stricken testimony instruction. During this trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. I have further instructions to read that are not that long, but I will do those after the attorneys do their closings. With that, the state can do their closing. If we can move the podium and have a microphone available.
No, just the podium. Thank you, though. Good morning, ladies and gentlemen. First, I want to thank you very much for your time and attention to this case. This was 2 very long days of testimony. The defendant is presumed innocent, has a constitutional right to a jury trial, so I thank each and every one of you for being a part of that process. Throughout these last 2 days, the state presented 20 witnesses and over 20 exhibits for you to view. I told you on Tuesday that the majority of this case, counts 1 through 8, occurred in 33 seconds. You saw those 33 seconds over and over and over and over again. Again, as I said, that's the beauty of technology. You saw a body camera, surveillance video, squad video. Not only of those 33 seconds in real time, but also slowed down and stabilized. And you saw the investigation that happened thereafter. Based on all that evidence, the state has undoubtedly proved this case well beyond a reasonable doubt. So let's look at the counts charged. The first 3 counts are first-degree recklessly endangering safety. The state has proven beyond a reasonable doubt that the defendant endangered the safety of deputies Courtroom, Avila, and Tift when he recklessly fired at officers on 2 occasions. You heard testimony from Deputy Courtroom about that very first shot where they're running up the driveway and the defendant produces a firearm and with his right hand puts it between his left arm while looking back and recklessly fires behind him while moving at the 3 deputies behind him. Deputy Courtroom testified with clear memory how he heard the shot, how he saw the gas come from the firearm, and how it was at him. You heard testimony from Deputy Avila, how when the defendant was on the ground with canine rigs, the defendant fired towards officers. Deputy Avila, again, with clear memory, testified how he saw the flash of the muzzle, how it was at him, and how, for a brief moment, he thought that he had been hit. He talked about how he paused, kind of did an assessment, thought, maybe I'm hit in the head. Maybe this is it. I better at least get a shot off. And you see that in his body cam, how he's running and then kind of hesitates backwards and pulls up his firearm. That's him thinking that he's been hit. having seen that flash of a muzzle in his direction. And you heard testimony from Deputy Tift, who was within feet of the other officers, and how when the defendant again was on the ground with his canine, he saw the defendant shoot at him. This is criminally reckless conduct. Shooting at anyone creates a risk of death or great bodily harm. The defendant knew that when he fired willy-nilly behind him towards officers and when he fired at them head-on while on the ground. He was aware that that conduct created a risk to those officers. And that risk showed utter disregard for human life. The defendant did not care if those officers died. He did not care if they were struck or injured. He had only one goal in mind, and that was to get out of there. As I said on Tuesday, he had gotten out of Chicago, he had gotten to Kenosha in this stolen vehicle, and he was looking to move on. He did not care about the life or safety of anyone who stood in his way. So when he fired at officers, it was for utter disregard of their life. And he did so while armed with that weapon. And we know that that weapon was a firearm. We know that it worked. We know that it fired 3 shots. We know that because we found 2 of the casings and because of what the officers saw. And I submit to you, he would have kept firing had that gun not jammed, had there not been a misfeed which prevented him from firing further. Count 4 is possession of a firearm. I think that one's pretty clear. He clearly had that firearm and used it against officers as well as canine rigs, which leads me to count 5, harassment of a police animal. Again, I think there's absolutely no doubt that the defendant intentionally struck canine rigs with a bullet, knowing full well that canine rigs was a working law enforcement animal and that he caused him injury. As the defendant was fleeing from officers, he looked behind him. He saw the officers. That's why he fired that first round. And when he looked behind him, he had to have seen canine rigs on a leash being held by Deputy Tift, who was in fully marked law enforcement uniform, and they were operating fully marked Kenosha County Sheriff's Deputy squad cars. So the defendant knew full well Canine Riggs was a law enforcement animal. And when Canine Riggs did his job, did what he's been trained to do for the last 10 years, and that is bite and hold the defendant, again, knowing full well he was an officer, took his firearm, pointed it directly at Canine Riggs's head, and shot. But for the grace of God, Canine Riggs is still here today. But he did sustain injuries. You saw pictures of his injuries, the entrance wound to the middle of the dog's forehead and the exit wound behind the right ear. You heard testimony from the treating veterinarian who talked about how his demeanor was dull, how he required anticonvulsant medication, antibiotics. He required a 3-day hospital stay, how they were worried about abscess, how he suffered the human equivalent of a concussion with a bruising to the inside of his brain. And that was undoubtedly caused by the defendant and done so intentionally. And that also goes to count 6, mistreatment of animal while armed. Again, he treated Canine Riggs in a cruel manner by shooting him. I don't know what could be more cruel than shooting an animal. He shot him again, point blank, in the head, intentionally, causing unjustifiable injury and unnecessary pain and suffering. Again, he knew that Canine Riggs was a police dog, and he used a weapon to cause him that injury, pain, and suffering. Count 7 is failure to comply with officers' attempt to take him into custody. Again, all the evidence has proven this beyond a reasonable doubt. The defendant intentionally refused to comply with officers' attempts to take him into custody when he remained at Benson's corners and retreated and remained armed while doing so. Again, Mr. Brown had no intention of going into custody. He had no intention of being held responsible for any crimes committed by him. He had one goal: to get out of there and to escape. So regardless of lawful commands, regardless of a canine holding him down, he fled and refused to comply with their attempts to take him into custody. It was only after officers did what they hoped they never have to do on a job, which is shoot him. It was only after he was shot that he was taken into custody. Count 8 is operating a motor vehicle without owner's consent while use of a dangerous weapon. Again, I think the evidence has shown beyond a reasonable doubt that the defendant drove or operated Miguel Padilla Jr.'s vehicle without his consent. You heard testimony from Chicago Police Department detectives, as well as local law enforcement agencies. The defendant knew he did not have consent to operate that vehicle based on the way that vehicle was procured. And he knew that. And he clearly possessed a firearm while operating that vehicle without consent. Not only did he have the firearm on his person when he fired at officers and canine rigs, in his backpack within the vehicle were additional ammo, I believe 15 rounds in one pocket and another round in another pocket, and there was also a casing found on the ground. So he definitely and certainly possessed that firearm while operating that vehicle without consent. Again, all 8 of those counts within those 33 seconds. The last count occurred October 29th, several days later. While in custody, he was receiving medical treatment for the wounds he had sustained while fleeing from officers. He had been arrested for counts 1 through 8 and was clearly in custody and being guarded by Racine County Sheriff's deputies. You heard testimony from Deputy Beal, how he was target glancing, especially that fire exit or fire stairwell at the end of the hall. On October 29th, doctors told him that he was ready to be discharged, and they were getting ready to transport him to the Racine County Jail, when again, the defendant tried one last time not to be held responsible for his actions. He took that opportunity when he was not arm shackled to the bed to try and run. You heard testimony from Deputy Beal, how he lunged forward, how she thought he was lunging at her, but instead he ran past her, pushing her aside, and ran for the door. But for Deputy Beal's quick actions, he would have been successful. But Deputy Beal immediately turned around and basically tackled him to the ground. Put him back into custody.
Jesus Christ.
And again, absolutely no doubt was what his intention was there. Again, he had escaped from Chicago. He had tried to escape from Kenosha, and he was trying one more time. Ladies and gentlemen, jury, with all the evidence you've heard, the testimony, the exhibits, the body camera, there is absolutely no doubt in this case that the defendant is guilty, let alone a reasonable one. And there is absolutely no reasonable hypothesis in this case that's consistent with the defendant's innocence on any of these counts. So based on all that, ladies and gentlemen, I ask that when you go back in the jury room, that you find the defendant guilty of all 9 counts. Thank you.
Thank you.
Okay,
So the
that
defense
was
closing.
the prosecution's closing argument. Oh,
If you
it will
could
be
just
the
state your
other
name for the
attorney
record,
doing
so the transcript's correct.
the closing arguments. That
McKenna Quinter.
might explain why it will take longer than 32 seconds.
33 seconds. From start to finish, the most important part of this case is 33 seconds. The state's correct in that. We heard a lot of testimony about those 33 seconds. We heard from Deputy Coltrip, Deputy Avila, Deputy Wyand, and Deputy Tift. They all came up here. They went over step by step by step their versions of what happened on that day. You heard lengthy testimony about it. But this incident wasn't lengthy. 33 seconds. It was quick, it was intense, it was stressful. All things that can leave a situation a little unclear, can make recall harder. But who could blame anyone for that in this type of situation, right? But even understanding that, that still leaves inconsistencies. There are not 4 victims in this case. There are 2. Christopher Johnson from the Wisconsin State Crime Lab came up here and testified to the evidence he collected. That's why he was on scene. That's his job. That's why the state brought him here to testify. He said they collected 2 .32 caliber shell casings. The state even asked, it's normal to have missing shell casings, right? He says, no, it's not normal. They used metal detectors, canines. They were on their hands and knees searching through the grass. And no one finds a third .32 caliber shell casing. Deputy Conley says, maybe it got stuck in a boot. Maybe. 2 shots. 2 .32 caliber shell casings. The state wants you to believe that there are 4 victims, that 1 bullet from 1 gun went in the direction of 3 officers. 3 officers who, by their own testimony, were in different directions from Mr. Brown. Some said 20 feet away from one another. Deputy Coltrip said 10 to 20 yards, depending on which officer you're talking about, but a substantial distance apart. It is not substantially likely that 1 bullet fired in 1 direction is going to endanger the safety of 3 people who are such great distances apart. And your common sense will tell you that. You've been told you can use your common sense. Your common sense will tell you that a bullet fired in 1 direction is not just going to veer 20 feet to the left. It's not going to go 10 yards to the right. And if you don't trust your common sense, Deputy Conley actually testified to that a bullet fired in a direction, it will indeed go straight. In fact, the only testimony we have about which direction this bullet was fired is contradictory. 2 shots, 2 shell casings. But Deputy Coltrip says he fired directly at me. Deputy Avila says, no, he fired at me. He stopped, he had to check himself. He fired at Deputy Avila. And Deputy Tiff said, no, he fired at K9 Riggs. And the state says, just pick one. Had to go towards somebody. Beyond a reasonable doubt, just pick one. I'm not here to tell you that you have to approve of Mr. Brown's actions. That's not why you're here. Your job is to hold the state to their burden beyond a reasonable doubt. And they're telling you beyond a reasonable doubt, just pick one. That's enough for those first 3 counts. At the start of this case, my co-counsel came up here and he said, he asked you to keep an open mind, to listen to the testimony, to watch it. And you've done that over the last 2 days. That is exactly what you did. And you saw the inconsistencies and you heard them. He also asked you to hold the state accountable to their burden beyond a reasonable doubt. And I'm here to ask you to do the same thing, to hold the state accountable, to hold them to that burden of beyond a reasonable doubt, and ask that you find Mr. Brown not guilty of these charges.
Very
Thank you.
short.
The state's rebuttal.
But it seems like they only focus
Thank you, Your Honor.
on
I'll be brief.
the shooting, not anything else.
Attorney Quinter indicated that this was a quick, intense, and stressful situation, which leaves inconsistencies in testimony. And I agree. But it doesn't leave inconsistencies in digital evidence. And that's why I had you watch the body camera over and over and over again, almost ad nauseum at the point we were done. Because while officers
I
are
agree.
trying to remember something that happened quickly and trying to remember it over a year later, again, body camera and video evidence doesn't lie. And that evidence, if you listen to it carefully, as Investigator Conley did over
Yeah,
35
but-
times,
Yeah, just the first
shows
three
you
counts,
that the defendant fired 3 shots.
not the dog. That's a very,
It shows
very
you
weird.
that he fired it
Yeah.
at officers. And I submit to you that even the first shot is enough to find the defendant guilty beyond a reasonable doubt of the first 3 counts. Because anytime you fire behind you while running, without looking at moving targets, you endanger the safety of anyone in that area, because you could strike anyone. And all 3 officers were in that area. They were all chasing the defendant. And he recklessly endangered their lives, not only with that shot alone, but also the subsequent shot, of which there is clear testimony. So we are not asking you to speculate. We are not asking you to guess. We are asking you to follow the evidence, which in this case shows beyond a reasonable doubt that the defendant is guilty. Thank you.
All right, the closing of arguments have now been completed. Members of the jury, the
20 minutes
duties of
in total?
counsel in the court have
Was it?
been performed. Case
Yeah.
has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. Time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You'll be very careful and deliberate in weighing
Hello,
the
please.
evidence.
Welcome.
I charge you to
You're
keep your
welcome
duties
to watch
steadfastly in
the
mind
first
as upright
hour
citizens.
and 20 minutes.
Render a just
Watch
and
it
true
in
verdict. You are to
1.5
decide
speed because
only on whether the
not,
defendant is guilty or not
fast-moving.
guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. Unanimous verdict and selection of a presiding juror. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may be legally received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note to the bailiff signed by the presiding juror to have a complete record of this trial. It's important that you communicate with the court only by written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any question in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you reach a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, we will swear in the bailiffs if they could come forward.
I believe that is Judge Schroeder's younger brother.
private and convenient place, subject to the direction of the court, until they've agreed on the verdict or discharged by the court, and that you will not before the verdict communicate to any person the state of deliberations or the verdict they've agreed upon, so help you God.
All right, the bailiffs have been sworn. You can follow the bailiffs. You can start your deliberations. Again, folks, we'll bring you in lunch today at 12 o'clock, okay?
They can begin at lunch, I believe he said. So,
All right, the jury is outside of the courtroom. The attorney should be available. If you're going to go anywhere, leave a phone number. But if we have a question, I want you back here as soon as
I
possible.
agree, Amanda.
And if we do have a question, we're going to have the defendant brought back also. So anything else before we break away from the state?
No, thank you.
Anything else from the defense?
No, thank you.
All right. Again, leave a number. We want you back here immediately. Thank you. And we'll call for the defendant if we need him.
Okay. That seems to be... We are on verdict watch. I have no idea how long it will be, but I saw in the chat about the gun. I presented that yesterday. I will see if I can share that. There. No, there. This is a cut through of a Luger PP. Sorry. I want you to count the number of bullets. 1, 2, 3, 4, 5, 6, 7. And with room for one in the chamber. 8 in total. Now, I don't believe that the defendant is smart enough to have a bullet in the chamber. That leaves 7 in the magazine. They found 5 unshot. 7 minus 5 is 2. That complies with the 2 shell casings. So the first witness, Officer Colin Coltrip, testified. I rewatched that bit. Yeah, exactly, 5 in the gun, which complies with 2 shots fired and 2 found shell casings. Which means the first witness from 2 days ago, Colin Coltrip, testified. I went back to rewatch it, and he said that he first saw him fire, reaching under his arm. 1 shot down, 1 to go. He also testified that he believed the defendant shot 2, 3, or 4 more times, which we know is impossible, the higher end of it. Nothing, no evidence in this trial complies with that. Then it was Officer Juan Avila. I'm reading from the paper, my notes here. Did not see or hear shots before K9 was there. So no help for officer number 1. Claims he heard 2 or more shots from the defendant. So it's vaguely close. Then it was Officer Waynard, who claims he heard 2 shots. He also heard no prior shot. Then it was Officer Tift. Those were the 4 officers on the scene who said, well, he was, according to his testimony, more or less he was the only one with a clear view of the gun. he only testified of seeing one shot fired. But his body camera did not work. According to himself, it was on photo mode. Of all the officers on site, everybody else has worked, except his. The only one with an actual clear sight of what happened, according to my interpretation of the testimony. But we can see 7 in the mag. 5 were left. And that was with the jammed one. So at most, there were 2 shots fired. So either Officer Coultrip, the first one, was wrong, that the defendant did not fire a gun at him. None of the other officers testifies to this. Now, when we watched the video, we heard shots fired, a pause, and then hell broke loose. Now, according to me at least, it was not clear that there was a shot fired under the arm shot. I didn't see on the body camera a muzzle flash or smoke. And none of the other witnesses on scene testifies to that they heard a shot fired at the underarm shot. Or he fired twice at, on, or in the direction of the dog. Yes, one in the chamber, if you have the knowledge of a Luger that you can do this. Not everybody knows this. I highly doubt that Mr. Brown has this knowledge about an almost 100 years old gun, that you can put one in the chamber and reload another one in the mag. So my assumption is there were only 7 in the mag. Now, if you filled the mag and had it cocked beforehand, that leaves 1 in the chamber and 6 in the mag. That could show that, well, that could show almost anything. I will think about that until my mock defense closing I will record later on. Yep, have fun, Troy. Have fun, Troy. So the inconsistencies in the testimonies, then if there are those inconsistencies, you have to look at the physical evidence. And they did only find 2 shell casings. That to me says only 2 shots fired. Either he fired at the officers or at the dog, or towards the dog, or in the direction of the dog. That is my opinion about how this shooting occurred. But this is how we have discussed our way in the chat, how I see the evidence. There's no saying what the jury says. Who knows? There might be a juror in there who knows this about an old Luger. You're in Wisconsin. Obviously, there are a lot of weapons in Wisconsin. And yeah, I will bring myself back up again. So that is the 3 first counts. Now we come to the matter of the dog. I have rewatched these videos over and over again, and there is one moment there that I will save for my mock defense closing that is a stretch, but yeah. Hit like and subscribe. Yes, please, please. Like, subscribe. I believe I present good content. I hope you like watching me stream and my videos. Now where was I? Yeah, now we can rewatch the last hour of yesterday, because there is some things I would want to show you. I hope it's no. I think it's this one. Because there is some issues I have with that last witness I want to discuss with you. Okay? They had a fire tool, weapons tool mark guy there yesterday, but as I said this on numerous occasions, tool marks are shit science. Unless you have something else to compare with, you only have these 2 bullets, and if they are close enough, yeah, I can say it's close enough. But you have to blind test them as well against other shell casings from other guns of the same mark and model. And that has to be blind tested by someone else. That person from 50 shell casings and that shell casing can say, this one is it. And you never hear that in a trial. And that is why it's shit science, because if they did that, the margin of error is astronomical. They might as well do a coin toss on every shell casing. But let's watch the last hour from yesterday about that witness, because in my opinion, well, hour 40 minutes, I will pull it up in 0.25.
Okay.
But I didn't think I actually physically saw him again.
But there was no need for his handler to bring him back to you for treatment, correct?
No, and like I said, we're a specialty facility, so most patients do not do follow up with our facility. They usually do follow up with their day veterinarians.
I have no further questions, Doctor.
Any
Thank you.
cross?
Yes, LS16. And welcome, LS16.
No, thank you.
All right, you're excused, doctor. Thank you. Have a good day.
You're all right,
That
move
was the
exhibit
last of the
23
doctor we heard
into
yesterday, and
evidence.
which was irrelevant, more or less.
23 there. All right, 23 is received. Next witness.
Next witness is Deputy Jamie Beal, number 5.
Yeah, standard practice, but this gentleman, Mr. Brown, is not a standard individual, which is why I come to that conclusion. Water, no, they testified to a Luger PP, not a Walter PPK.
You just remain standing, raise your right hand, I'll swear in. You solemnly swear the testimony of this matter be the
But I will go back and rewatch what they testified to.
Get as close as you can to the microphone. Spell your first and last name for the reporter.
First name is Jamie, last name is Beal, Beall.
Thank you. Go ahead, counsel.
Thank you. How are you employed?
I'm a sheriff's deputy with the Racine County Sheriff's Office.
How long have you been a law enforcement officer?
I was hired in September 2019.
No, it's the wrong one.
What are your current duties?
That one we listened to yesterday. It is this one.
He was in the doorway when I grabbed him.
Okay, but he never made it into the hallway, correct?
No?
I guess it would, depending on what.
Redirect on that.
No.
All right, you're excused. Thank you.
Oh yeah. Forgot about that. This is the person they claimed stopped Mr. Brown to run out in the hallway. This police officer woman is, I don't know, 5 foot -2, 120, 130. If he ran outside, there is no way her clinging to his waist would have stopped him going anywhere, in my opinion. She does not have the weight to it, in my opinion. So is it evidence, or is it anything like a reasonable doubt? Yeah, I hope that the jury looks at her. They have seen the defendant during the trial, who I believe is 5'9", 5'10", 170, 180. If he wanted out the door with her around his waist, he would have gone out the door. He never got out the door. The fish. Yeah, okay. Let's say it's the fish she's measuring. Sorry. My sisters will kill me. Let's go on to
Redirect on that?
No.
All right, your excuse, thank you.
this witness is
Thank you. St.
interesting
Paul's investigator Susan Conley.
because this witness is the person who was the only one
When you come up here,
the defense
raise your
objected
right
to
hand. You solemnly swear the testimony is meant to be the truth, whole truth.
or
and nothing but the
objected
truth,
to
so help you
parts
God?
of her testimony.
All right, spell first and last name for the record, and then you can start your questioning. Go ahead.
Susan Conley, SUSANCONLEY.
Thank you.
Thank you. How are you employed?
I'm an investigator with Racine County Sheriff's Office.
How long have you been a law enforcement officer?
10 years,
How long have you been an investigator?
6 years.
Do you have any special education or training that qualifies you to be a law enforcement officer?
I completed the Law Enforcement Academy at Gateway, and I also have a bachelor's degree in criminal justice.
And to become an investigator, did you have to undergo any other additional training or education?
Not to become an investigator. Once I became an investigator, I got a significant amount of on-the-job training, one of which included the DCI investigating officer-involved shootings.
So let's talk about that training. What is that training?
It is at the time I took it, I'm not sure what it is now, is a 4-day training with agents from the Division of Criminal Investigations with the state of Wisconsin, who essentially teach you how to conduct an investigation into an officer-involved shooting or critical incident.
And can you just bring the mic up just a little bit closer? Thank you. To your knowledge, are you one of the only individuals in your department who went to that training?
At that time, I was, yes.
So on October 21st, 2021, were you working as an investigator?
Yes.
At some point that day, did you receive information regarding an officer-involved shooting in Kenosha County?
I did.
How did you receive that information?
I was out to lunch with Sergeant Sheriff when he received a phone call from the patrol division captain that they were requesting our assistance to lead the investigation into the shooting.
And being one of the only ones trained in investigating officer-involved shootings, were you then put in charge of the investigation?
I was.
So upon receiving that call, what did you do?
She's extremely giggly about this.
We responded back to the patrol station where I gathered up some items that I thought I might need to use once I got on scene. We did a little bit of verbal coordination about who was going to do what once we got there, and we all responded in our individual squad cars to Benson Corners.
And when you say we, who were you talking to in this initial debrief?
For the most part, it was Sergeant Sheriff and I. When Sergeant Sheriff was an investigator, he had gone through that training at the same time as me, so we sort of agreed at that point that he would be my second, but that I had to take lead since he was the supervisor.
Before arriving at Benson's Corners, what information did you have about what had just occurred in Kenosha?
I had very little information at that point. I was only aware that they had been involved in a shooting, that at that time the individual who had been shot had survived and had been transported to the hospital.
What was the first thing you did upon arriving at Benson Corners?
I made contact with the command staff with the Kenosha Sheriff's Office in their mobile command vehicle that was on scene. I got a briefing from them, and that was the point at which I was provided the information regarding the context of their contact with the Buick and subsequently with Mr. Brown.
And what did you learn?
That the vehicle, that Kenosha County Sheriff's Dispatch had been advised that a vehicle that was stolen during a homicide overnight had been, OnStar had located that vehicle in the parking lot at Benson Corners. Kenosha Dispatch sent deputies to check for the vehicle, and upon attempting contact with that vehicle, the operator or occupant fled from them. There was an exchange of gunfire that resulted in Mr. Brown being injured. K9.
Objection, speculation, objection, hearsay. They had already witnessed, compound. Lots of things objectable here, in my opinion.
And Riggs being injured, and we got where we were.
All right. So what were your specific duties on scene at Benson's Corners on October 21st?
So leading an officer-involved investigation is somewhat unique because what I'm being tasked with is determining whether or not the officers engaged in a shooting that was within legal parameters. So I'm not so much at that point worried about how they got there, only what happened once gunfire began being exchanged. So after meeting with the command staff, I then did a scene walkthrough, and just to get kind of an idea of the scope of the interaction, I guess. I then had to coordinate with my own other investigators. We had to do the photographing and inventorying the deputies' uniforms. So there's a lot of delegating on my part, but there's also a lot of things that I'm ultimately responsible for doing. So I ended up being essentially the liaison for the crime lab once their response team arrived, and we kind of worked in tandem once they were there to process the scene.
So fair to say you assisted Christopher Johnson in kind of his team in collecting evidence, correct?
Yes.
You said that were you present when the officers involved in the shooting were photographed and the round count was done?
I was kind of in and out. They had been moved to the county building. And at one point, I think while we were waiting for Chris Johnson and the crime scene response team to arrive, I did go over there briefly and make contact with them, mostly just to make sure that they were okay and just to explain what my process was going to be and why I was doing the things that I was doing with regards to their uniforms and their firearms and all of that.
So on that day, you saw what firearms the Kenosha Sheriff's Department deputies were using, correct?
Yes.
What type of firearm do they use?
Glocks,
Do you know what specific caliber?
9mm.
So in summary, on October 21st, your role is basically delegate, supervise, make sure everything's being done as it should, correct?
Correct.
From there, did you also collect body camera video from all the officers involved in the shooting?
That was more in the days to come. There was a lot of video. There was body camera footage from 3 of the 4 deputies who were involved. Not only do they have forward-facing squad cameras, but they also have backseat squad cameras, and so they're all on that whole time. So I had to, from Kenosha County Sheriff's Office, I had to get that information, all of it, and I had to go through all of it.
Did you review the surveillance video from Benson Corners as well?
Yes.
Be fair to say any digital evidence collected in this case you personally reviewed?
Yes.
Did you also collect dispatch recordings?
Yes.
Which dispatch recordings did you collect?
I collected the initial phone call received from the Chicago detective, as well as the OnStar call that was made to dispatch. And I got all of the radio transmissions from the time that they were dispatched through their conclusion of the event.
And did you review all that evidence?
Yes.
And when you were reviewing the body camera, the dispatch logs, the radio traffic, You took detailed notes, which you put in a report, correct?
Yes.
That would also include the Benson surveillance video, correct?
Yes, I believe so. I wrote a lot of reports.
We'll get back to your review of the digital evidence in a minute. You also were involved in interviewing the deputies who were involved in the shooting, correct?
Yes.
When did those interviews take place?
I want to say October 25th.
That would be that Monday, October 25th?
Yes.
Why did you interview the deputies on October 25th instead of right after the shooting on October 21st?
It is standard practice anytime an officer is involved in a critical incident that they are given a minimum of 3 sleep cycles before they're expected to make any sort of official statement.
And why is that?
The way that the brain works in traumatic events, I don't know necessarily the whole science behind it, but the standard practice is it permits them to process the event and recall, have better recall of the details of
We're
that.
going to stop right now, folks. Go take a.
Did you hear that? They give police officers a minimum of 3 sleep cycles before the interview, so they can correctly remember the event. Now, in my experience, you have to interview eyewitnesses as soon as possible. So why are these officers allowed 3 sleep cycles over the weekend before they are interviewed? In my opinion, this leaves way too many openings to the officers getting their testimonies somewhat close to each other. Exactly, GD. Exactly, KT. Exactly, Fenris. Sorry. Yes, Papa G. This is from the police union. For me, this is astounding that this is allowed. I don't. Now remember, I'm a union rep. I like unions. Police unions, in my opinion, I'm not a fan. And I say this as a union rep myself. I am not a fan of the police union. In my opinion, and I will stand by it, they have more interest in getting their members off. Now that's not abnormal, but even as a union rep, you're not supposed to hide things. You're not supposed, if you suspect as a union rep that a crime is being committed, you should report it, even if it's from a member. I know. Correctional officers don't have the same rules, I believe, as police. I'm not sure how it is in Texas, though. But I read up a bit about how it is in Wisconsin, and what she says is correct. And it is that way in many states. And for me, it is astounding that they gave the police 3 sleep cycles over a weekend. What's even more astounding is that there are still inconsistencies in the officers' testimonies, which actually tells me these police officers might be giving their actual memory of the event, and that's why there are inconsistencies. In my opinion, the stretches in this case comes from the prosecution. They only found 2 shell casings. That's it. That means they could only prove 2 shots. And if 3 police officers testify that they didn't hear or see the first shot that was alleged by the first officer, that inconsistency in itself should provide reasonable doubt on one of the 3 charges, which was actually brought up by the defense, which should have been clearer, but it was at least better than the opening statement, that if there are 3 choices, there are reasonable doubt to each and one of these 3 choices. But if they find that the first shot was against Officer Courtroom, and the second shot was against what Wayand, the last officer, testified to, then that should mean that the round hitting the dog did not come from the defendant. Let's continue.
Good break, okay? Don't talk about the case.
Okay, they
You can
were
stay
taking
right
a short
there.
break here.
Thank
I will push forward. Yeah, if you don't want to testify as a witness, you might as well be locked up.
All right, we're back on the record.
If
on
you're an
Allan
eyewitness.
Brown, 21 CF 1344. The appearances are all the same. Jury is back in the courtroom. The witness is still under oath. The state can continue with their questioning.
Thank you. So on October 25th, you interviewed all the officers involved all the Kenosha officers involved in the shooting, correct?
Yes.
Another step you took was to search the 2016 Buick Encore involved in this case, correct?
Yes.
When did you search that vehicle, if you can recall?
October 22nd, I believe.
Where was that vehicle searched?
It was secured in our indoor impound at the sheriff's office substation in Racine.
How did that Buick get from the scene of Benson Corners to the impound?
It was towed there via flatbed and followed by one of our investigators.
Who was involved in the search of the Buick Encore?
Myself and now Lieutenant Sheriff.
What was your role in searching this vehicle?
We sort of split the vehicle. Initially, the plan had been for Investigator Johnson to take the photos and Sergeant Sheriff and I would search. He had to leave for another obligation.
I'm sorry, Becky, you mean?
Investigator Johnson.
Okay.
And Sergeant Sheriff took over most of the photography while I searched one side of the car without really finding much of interest. He searched the other side and photographed as he went.
And
I agree.
Now Lieutenant Sheriff
Separated
found pretty much
video
all the evidence of
statements.
evidentiary
Yes.
value. Okay.
Immediately after.
You also swabbed the vehicle, correct?
Yes.
And how did you do that and why?
I did it by using sealed evidence kit or DNA kits similar to what Investigator Willis described to you guys. I did that for the reason of just establishing any touch DNA that might be present
I agree.
in case there was a question about whether or not Mr. Brown had been inside that vehicle. And so, yeah.
That day you also drafted a search warrant for Mr. Brown's DNA, correct?
Yes,
Did you execute that search warrant?
Investigator Willis did.
You also were responsible for sending items to the Wisconsin State Crime Lab, correct?
I was responsible for drafting the transmittal requests and forwarding them to our evidence custodian, and he would then receive my requests and transport the items to them at the crime lab.
And what's a transmittal form?
Anytime there's something that we want to have taken out of our storage and taken to the Wisconsin State Crime Lab for processing, the crime lab has its own, what they call a transmittal form, where I fill out on there all of the relevant case information, all of my relevant information, and then I line by line list each item of evidence that I am requesting that they take receipt of.
Would it be fair to say you're the one who decided what went to the lab and what you wanted to have tested?
Yes, there were also conversations that I had with the crime lab regarding their capabilities and what they could process.
I don't disagree,
but ultimately, the decision was mine. Yes.
So going over what you sent to the crime lab, first you sent all the bullets, casings, and firearms involved to the crime lab, correct?
Yes.
For what purpose?
To try to establish what ballistic evidence came from what firearm mostly.
We heard testimony from Mr. Chadwick about the Walter PP. Based on your investigation, whose firearm was that?
Allan Brown's.
We also heard Mr. Chadwick testify that he looked at 2 other firearms. You heard that testimony, correct?
Yes.
Whose firearms were those?
Deputy Colin Coltrip and Deputy Terry Tift.
And those would have been the 9mm, correct?
Yes.
You also sent down a thumb drive containing Deputy Coltrip's body camera footage, correct?
Yes.
What was the purpose of that?
I was trying to, so my request was for them to analyze it and attempt to slow it down because I was trying to determine a definitive number of shots fired. I was having a hard time being able to differentiate just by listening to it at full speed, the number of shots from the deputies.
You also sent down a buccal swab or DNA swab of Mr. Brown, correct?
Yes.
And what was the purpose of sending that down?
That was for them to swab the Walter firearm and make any comparison with DNA that they may have recovered from that firearm.
That was ultimately unsuccessful, correct?
Yes.
Now going back to the digital evidence, you reviewed
Pay attention here.
the body camera of Deputy Colin Coltrip, Deputy Juan Avila, and Deputy Patrick Wyan, correct?
Yes.
Approximately how many times would you say you reviewed these body camera footages?
I think that a conservative guess would probably be at least 10 times each.
So total 30 times you watched the incident. Would that a conservative estimate, correct?
Yes.
Did you also review the slowed down versions provided by the state crime lab that we saw in court?
Yes.
How many times would you say that you reviewed those?
5 maybe between all of them.
Why did you watch these videos so many times?
I watched them, well, I took very detailed notes as I watched them. So I was time stamping things as they occurred and then going back to make sure that I was accurate in my timestamps of those. I was also, again, trying to determine the timing of shots and trying to determine how many rounds were fired for sure from the deputies.
Were you also listening for how many shots were fired by Mr. Brown?
Yes.
In your 35 plus viewings of these body cameras, how many shots did you hear fired from Mr. Brown?
I'm going to object to this question. I think we've seen the videos. We've heard testimony from officers. I don't think Ms. Conley should speak to what the videos show.
Overruled. Go ahead.
That was the one objection in this trial. And this was a speaking objection. In my opinion, the objection should be either relevance, which is sort of hinted at, compound, because what she is about to testify to is her opinion about how many shots were fired by the defendant. And that is not up to her to decide. She is not the finder of fact. That is the jury. That should have been the objection, and maybe that objection would have been sustained. I don't know, because he didn't object to that. So in my opinion, this was the prosecution trying to fill in holes in the officer's testimony. They knew of the inconsistencies in the testimonies. And so they brought her on because she was doing the investigation of the officers to see, was this a legitimate shooting by the officers? And it is. But that should have been the evidence collecting, the investigations on the officers. Was their conduct wrong or right? But the prosecution also used her as a finder of fact, which I believe is a bad move. Probably not needed, but no, yeah.
3.
When in the series of events did you hear these 3 shots fired by Mr. Brown?
As he's running down the service road, and then as he's kind of tumbling into the grassy area.
Okay, so let's break that down. When he's running down the service road.
Oh, wait. You have to answer this way, is what I'm hearing from the prosecution.
Would that be before or after K9 Riggs makes contact with him?
Before.
And did you see how he fired that shot?
Yes.
Can you demonstrate for the jury how you saw him fire that shot?
So he was running eastbound and turned with the firearm in his right hand underneath his raised left arm and fired 1 shot.
And then you heard him and saw him shooting when he was in the grass, you said?
Correct.
Okay. How many shots did you hear Mr. Brown, see and hear Mr. Brown get off in the grass?
2.
How did you see that happen in your 35 plus views of this footage?
I don't necessarily see it so much as I hear it.
Objection. This witness is giving facts to the jury. Jury is the finder of fact. She is not an expert witness on hearing the differences between gunshot sounds. She can give an opinion, but she's not sworn in. This is compound. There are so much objections that could be raised here, in my opinion.
The distance from him to the deputies with the body cameras is such that it doesn't permit a visual observation of it, but I know what a gunshot sounds like, and there were 2.
Yeah.
The shot that you described first, the behind the back, under the arm shot on the driveway, what distance was that shot from the 32 casing that was located on scene on the driveway?
Yes,
Was it
they are
nearby,
public
far away?
defenders.
I would say probably within 10 feet.
And
Yes.
then there was only one
did.
casing, 32 caliber casing located in the grass area, correct?
Yes.
And where was that located in relation to when you heard him shoot twice?
Within a 5-foot radius.
You've heard testimony that only 2 32 caliber casings were recovered, correct?
Yes.
Based on your training and experience, is there a number of ways that someone can miss a casing?
Yes.
Does the size of the casing have something to do with that?
Yes.
Explain how.
The casings from a 32 caliber bullet are relatively small. They can be stuck in treads of boots. They can be caught up in.
Show the officer's boots. Is that enough space for a gunshot casing? Did they collect the boots? Not in objection, not in evidence.
And the tread of tires, if people are not.
Oh wait, this is from yesterday. He has these marks in his face yesterday too. I didn't notice them yesterday. Okay, I will go back to day one to see if they were there then as well.
Cognizant of that when they enter scenes. It can also just be like if somebody drove up and caught it on the edge, it could send it off beyond what our scope of the search was. I think that based solely on my observations, that's likely what happened because there were squads that pulled well into the scene at their initial response, not realizing the scope.
For example, deputies Gomez and Schmidt.
Objection, what's the word I'm looking for? Yeah, still objections. Sorry.
When they pulled into that driveway, would that be an example of two cars that went in that area?
Yes.
And obviously them exiting and walking in that area could also have affected that.
Yeah,
correct?
if you have it
Yes.
stuck under your boot, you will notice you have something on your boot. Okay, they've always been there. Okay. The markings on the defendant's face.
When you saw and heard Mr. Brown discharge the first fire behind his back,
Yeah.
could you tell in your review from the footage which officers were in the area where he shot?
Objection, compound. The law officers on site have already testified, but then again, but at least with an objection, you save it to the record.
I could tell for certain that Deputy Coltrip would have been in the area. I can tell based individually on each individual deputy's
Both?
body camera footage. So it would be Deputy Tift, Avila, and Coltrip, and my assertion to Tift is based on Avila and Coltrip's body camera footage.
So all three of them were in the vicinity of shots being fired at them?
Yes.
Objection, vague testimony. Speculation is the word I'm looking for.
All right, I have no further questions. Thank you.
Cross by the defense.
Thank you. Investigator Conley, we've heard testimony that the firearm Mr. Brown had jammed, correct?
Yes.
Could the firearm had made a sound when it jammed?
I would think not. That's not been my experience when experiencing misfeeds.
I have to agree with
But
that somewhat.
ultimately, we don't know where this third casing was, period.
Correct.
Okay. So in your review of the body cam footage, Mr. Brown only shot one time in the direction of officers, correct?
Correct.
And the officers were not, through testimony, they were not all standing in a line, right?
Most of them were still moving at that point.
But they were spread out from each other.
Correct.
And a bullet typically travels in a straight line, correct?
Correct.
So being feet apart, how can you determine that it was headed towards three different officers?
I can say that a bullet coming from a firearm that is also moving without a target being acquired cannot necessarily be directed at one specific place.
All right. No further questions. Thank you.
Anything on those questions from the state?
One thing, Your Honor. Speaking of the casings, we did hear testimony from Mr. Chadwick that he did analyze 3 casings, correct?
Yes.
We heard testimony 2 casings were from the scene, correct?
Yes.
Where did that 3rd casing come from?
The 3rd casing was found by Lieutenant Sheriff in the backseat of the 2016 Buick.
Yeah.
That's all. Thank you.
Anything on those questions from the defense?
No.
Did we mark any exhibits with this witness?
We did not.
Oh, all right. You're free to go. I should say you could sit back down. All right, where are we for witnesses then from the state?
I have one more witness in my case in chief, and that would be Lieutenant Allan Sheriff, number 19.
19?
Okay, I will let you listen to this guy, in my opinion, because I have to break off to get a small bite to eat. Welcome. Oh, we're up to almost 15 who watches now. Welcome. We're over 2 hours. You might
All the way up
hear
front here,
curse
remain
words,
standing, Deputy, and raise your
but I
right
will
hand. I'll
take
swear you in.
a
I swear the
couple of
testimony
minutes
is
to
going to be
get
the truth.
a quick bite to eat.
So help you God.
So listen to this.
Get as close as you can to the microphone. Spell your
meanwhile.
first and last name for the reporter.
Like
Allan
and
Sheriff,
subscribe.
KELLENSCHERFF,
Thank you. Go ahead, counsel.
Thank you. How are you employed?
Racine County Sheriff's Office.
In what capacity?
I'm a lieutenant.
Could you pull the microphone up so that it's very close to your
Oh,
face?
sure. Yeah. Is that better?
Yes, much
All
better.
right.
Thank you. How long have you been a law enforcement officer?
11 years.
How long have you been a lieutenant?
A little over a year.
What was your rank in October of 2021?
As a sergeant.
As a sergeant, what were your duties?
I was assigned to our Criminal Investigations Bureau.
And what are your responsibilities as the sergeant for the Criminal Investigations Bureau?
I supervise and coordinate the investigators in the Criminal Investigations Bureau.
Do you have any special education or training that qualified you for that position?
Yeah, basic law enforcement academy, as well as ongoing agency training, annual.
Additionally, did you have specialized training in officer-involved shooting investigations?
I did, yes.
I want to draw your attention to October 21st of 2021. On that date, were you on duty?
I was, yes.
And while on duty, did you receive information regarding an officer-involved shooting in Kenosha County?
I did, yes.
How did you receive that information?
I was notified by our operations captain, Captain Adams, via phone call.
And why were you being informed?
He was letting me know because I was supervising the investigators. He wanted me to get everybody together and brief them on Kenosha having an officer-involved shooting, and that we were going to go down there and handle the investigation for that.
Did you assign a lead investigator?
I did.
And who was that?
That was Investigator Conley.
Upon receiving this information, assigning a lead investigator, what did you do next?
We responded down to the command post location down in Kenosha at Benson's Corners.
And what did you do there?
We were briefed by the supervisors from Kenosha County Sheriff that were on duty, and given a briefing on the situation.
And generally, what was your role on scene that day?
My role was more or less is to assign people as tasks came in that needed to be completed. So I would assign investigators out to different tasks as they came in.
Did you also assist in looking for casings in the grass area?
I did, yes.
Did you locate any?
I did not.
Next, I want to draw your attention to October 22nd of 2021. Were you involved in the execution of a search warrant on a brown Buick Encore?
I was, yes.
Where was that search conducted?
That was at our patrol station in our pole barn.
What was your role in searching this vehicle?
I initially, Investigator Johnson had been there and he was taking photos. He had to leave for something, so I actually took over taking photos for him of the interior of the vehicle. And then I also helped with searching through the vehicle for anything of evidentiary value.
Did you locate items of evidentiary value?
I did, yes.
Let's first talk about in the front passenger seat of the vehicle. What did you locate there?
There was a cell phone on the seat.
Okay. What else was in that area?
Also a backpack.
Did you search through the contents of the backpack?
I did, yes.
And what, if anything, did you locate?
There were several 32 caliber bullets that were located inside of there.
How about identifiers? Did you find identifiers for anyone?
Oh, I did, yes. I found a birth certificate inside of, there's like a little baggie in there, and it was all folded up inside of a small baggie in the front pocket of the backpack.
Who was the birth certificate for?
Allan Brown.
You also located some prescription bottle, correct?
I did, yes.
And what was the name on that prescription bottle?
Also Allan Brown.
And it was in that same backpack you located the bullets for a 32?
Correct, yes.
How many bullets?
I located one, I believe, in the front pocket, and then there were 15 in the side pocket.
You also located a casing for a 32, correct?
I don't recall.
You don't recall the casing?
I don't know.
Okay, that's okay. As part of your duties, you said you took pictures, correct?
I did, yes.
If I showed you pictures from that, your execution of that search warrant, would you recognize them?
Yeah, I think so, yeah.
Sorry, no, it wasn't a 22, it was a 32. according to testimony and physical evidence. Nothing in testimony, nothing in evidence. Cup of soup. Yay. An Oreo flavored milk chocolate. I am not sponsored, but if anyone from Marabou Milk Chocolate Company is watching, give me a call. I'm available.
What number is it? Thank you.
I'm showing you what's been marked, exhibit 24. You can page through that, see if you recognize this photo.
I do recognize them, yes.
What are these photos of?
These are of the vehicle that was impounded from the Benson Corners gas station.
The brown Buick Encore, correct?
Correct, sorry, yes.
Do they appear to be true and accurate representations of what you observed on October 22nd of 2021?
Yes.
Your Honor, I'd move that exhibit into evidence with permission to publish.
Did you look at the photos, counsel?
I did have a chance.
All right, and they were identified by the witness, so we can publish them and show them to the jury.
Lieutenant, I'm going to pull them up on the screens and we're going to go through them one by one. They'll be the same as in your packet.
Okay.
So what's this a first photo of?
It's the rear of the vehicle.
The next photo?
It's also the rear passenger side of the vehicle. The passenger side. The front passenger side. Front driver's side. And the driver's side. Back driver's side.
Kind of a 360 of the vehicle, correct?
Correct.
All right. This is also the back driver's side?
Correct.
Okay. And another one of the back, correct?
Correct.
And this one has the license plate clearly shown, correct?
Correct.
All right. What is this next photograph of?
It's the interior of the driver's seat.
And I should ask, when you're taking photographs of a vehicle like this, is there a method to your photographing?
Yeah, we try to go in kind of an order that makes sense. So, oops, sorry. So yeah, we take the 360, start in one spot, work our way all the way around, and then same thing, open up the doors, take pictures of the inside from the outside, and then slowly get closer and smaller as we locate things.
Okay. So this is the front driver's side, correct?
Correct.
All right. This
I
next
will
photograph?
show you
The
back
front passenger side.
when I'm done with my
what's this photograph?
afternoon
Also the
snack
front
here.
passenger.
Zoom, getting closer,
Yep,
right?
getting a little closer.
Next picture?
That's the rear driver's side.
This picture?
Same rear driver's side, closer.
Next picture?
Rear passenger,
Next picture?
closer rear passenger.
And these photographs are also taken prior to you collecting or touching anything, correct?
That's correct.
Still allegedly, but
And what's this of?
That's the
the
car
lack
garage.
of defense. Yeah,
All right. Now we're back to the front
I
passenger
would
seat,
be
correct?
extremely surprised if
And is
the
this what you locate on the front passenger
jury
seat?
comes back
Yes.
with
The next picture
not
is of
guilty
what?
verdict.
Same thing, front passenger.
But we've
Looks
been
like you
surprised
opened the
before
bag to see what was in it, correct?
watching trials
Correct, yes.
from Kenosha
And is this
County.
this next picture is of the contents of the bag?
That's correct.
Looks like some water and some beer.
Yes.
And what's this next photo?
Phone that was underneath the bag.
Another picture of the phone.
Same, yep.
And what's this a photo of?
It's the backpack that was located on the floor.
And what is this a photo of?
Beer can on the floor.
No,
Also looks like a drawer. Would that be accurate?
Also, what? I'm sorry.
A drawer?
Oh, yes, correct.
And would that be located under the passenger seat?
It is correct.
And what is this a picture of?
It's some paperwork that was found inside the vehicle. Looks like belonging to Miguel Padilla.
It looks like also it's related to that, or at least some vehicle, correct? Some mileage at
Yeah.
purchase date, mileage at base date loss, correct?
I'm not exactly sure what it is. I'm trying to read it, but there's a little bit of a glare on the
Sure,
plastic too.
sure. But you can clearly see it's related to a Miguel Padilla, correct?
Correct, yeah.
All right, what is this a picture of?
That's the backpack that was located on the floor.
Looks like you've taken it off the floor and put it on the seat. Is that accurate?
Yes, correct.
And what are you doing in this next picture?
Opening up the side pocket there and just showing the contents before I take anything out.
And it appears you are wearing gloves, correct?
Correct.
And what's this next picture? The contents of the pocket?
Yeah, it looks like the contents of the pocket.
And what is this a picture of?
That's the top pocket, and you can see that there's a pill container inside of it.
And the next photograph?
Just a close up and showing the name that's on the front of the pill container.
Again, that's Allan Brown, correct?
Correct.
Next picture, just another close up of that.
Yeah, less blurry version.
All right. And what's this a picture of?
Also the same pocket, just the inside.
And what is this a picture of?
The contents that were in that pocket.
They're building foundation
Looks
to
like some
what's
change, some
found
guitar
inside.
picks,
And they
some other
claim
just random items. Is that fair?
Yeah, correct.
shell case
What is this a
was
picture of?
found in the back of the
That's
car.
the front pocket unzipped before anything was taken out of it.
Of the same backpack, correct?
Correct, yes.
And what is this?
And those would be the contents of that pocket.
Looks like some clothes and maybe some hygiene items.
Yes.
And what is this a photo of?
So the zipper pocket there, just being opened up before anything's taken out of it.
And that's the contents of that pocket, correct?
Yeah, those are the contents.
What stands out to you from this picture?
That little baggy looking thing there at the bottom. Yep, right where the mouse is. That was actually the birth certificate that I found in there with Allan Brown's name on it.
And how about this item that I'm circling with my cursor?
That's the 32 caliber round that was found inside that pocket.
And what is this next picture of?
That was the birth certificate that was folded up inside that baggie.
If I see if I can just zoom in a little bit, can you see the name?
Yes, Allan Michael Brown. Mitchell, sorry, Mitchell.
Allan Mitchell Brown.
Correct.
All right, I'll zoom back out. The back, this next picture, the back of the birth certificate.
Yes, correct.
All right, what is this a photograph of?
It's the photograph of the inside of the rear passenger.
And what is this a photograph of?
Just the contents, the floor.
And zooming
And
in.
there's- Yep, shell casing on the floor.
So does this refresh your recollection as to finding a shell
It
casing?
does, yes.
Okay, and is this before you collected the shell casing?
That is correct.
So the next photograph, what is that of?
That's a close-up of the shell casing still sitting on the floor in the vehicle.
And what is this a photograph of?
The front pocket unzipped.
Again, of this
Backpack.
backpack?
Yes.
And what is this a photograph of?
The contents removed out of that front pocket.
Yeah, I would
Again,
guess
appears to be some
so.
hygiene items,
But
correct?
at best, he
Correct.
gets another try.
And this, what is this a photograph of?
Unzipped
And,
side pocket.
They did object once,
Of that same
and they
backpack.
did ask
And the next picture just
a
zoomed in a
few
little bit more.
questions
Yes.
here and there.
And this next
I'm
picture
not
zoomed
sure
in even
that if
further,
that
correct?
Correct.
What are you trying to document here?
reaches
The
the bar.
you can see that there's a bullet inside of there, so you get to see the top of that one.
Would it be this shiny part in the middle here?
Correct. Yes.
The next photo, what is this a photo of?
Those are the contents that were inside of that pocket with the 15 additional 32 caliber rounds that were found.
And what is this a photograph of?
It's the back markings that are on those bullets.
If I zoom in, can you see what it says?
See, it says 32 auto across the bottom.
Do you know what these markings are on this side? The right side?
I think, does it say R&P? Sorry, I'm guessing. I'm not 100% sure.
Okay. If I zoomed in more, does it look like R&P?
I think it says RP. Yes.
Does that mean anything to you as a law enforcement officer?
No.
No? Okay, that's all right. But clearly it says it's a ammo for 32, correct?
Correct.
And what is this a picture of?
An envelope that was located.
Zoom in.
Oh, I'm sorry. And sorry. That's the Fire 32 casing right there in my hand.
And you're putting it into this
Into
labeled package, correct?
Yes.
And what is this a photograph of?
Also the Fire 32 casing.
I'm gonna zoom in. How can you tell it's the fired casing versus one of the bullets?
I can see the indentation on the primer on the back of the round.
Be this little indent in the middle here where my cursor is?
Correct.
And why does that indicate to you that it was fired?
Just based on experience, I know fired casing, firing pin's going to strike that, and that's how bullets work.
Okay. All right, next photograph.
Outside of the side pocket of that same backpack,
And the next photograph.
and the contents of that pocket.
Okay, looks like some change, a lock, and like a little baggie.
Correct.
Next photograph's just another picture of those contents.
Yes.
All right, and what is this a photograph of?
Looks like the inside of the
Hey,
main pocket of the
Tony,
backpack,
good to see you.
And the next photograph
and the contents of that pocket.
appears to be just personal belongings, correct?
Correct.
And that should be the last photograph in your packet. Can you just confirm that?
Correct, yes.
Anything of evidentiary value located in this main compartment?
I don't believe so.
All right, I will take that off the screen then.
Grounds! Grounds!
All right, that's all the questions I have. Thank you, Lieutenant.
Any cross for the lieutenant?
No, thank you.
All right, have a good day. Thank you. Did you move 24 in then?
I believe I did, but if I
Okay.
didn't, then I will again.
24 is in then.
At this point, Your Honor, the state rests.
Okay. Go back there and take another break, folks. We got to do some discussions here between the parties.
Well, because every day he's in court, he's not in jail. That's why Brooks does what he does. Yeah, I don't know. That's it. He has that private citizen bull crap going on, and he will argue it in court, and it will take a lot of time, and that's time he doesn't have to spend in prison. So now you have seen the shell casings, the gun of sorts, and everything. I will see if I can find the shell casings guy again, the tool mark guy. And because I'm still amazed how the tool mark guy is supposed with testimony isn't just booted out of court with embarrassment.
All right, we're back on the record on Allan Brown, 21 CF 1344. Appearances are the same. Jury's back in the courtroom. We're going to continue with the state's case in chief. Next witness for the state.
Thank you. State calls Troy Chadwick, number 7.
Let's welcome Shad, the tool mark guy. Sorry.
I ask you to remain standing, raise your right hand. You solemnly swear the testimony in this matter be the truth, whole truth, nothing but the truth, so help you God? Thank you. Get as close as you can to the microphone. Spell your first and last name for the reporter.
Troy,
Brooks as a
T-R-O-Y.
defender.
Last name
Oh.
Chadwick, C-H-A-D-W-I-C-K.
Thank you. Go ahead, counsel.
Thank you. How are you employed?
I'm a firearms and tool mark examiner at the Wisconsin State Crime Laboratory in Milwaukee.
How long have you held that position?
I've been at the crime laboratory for a little over 10 years, and I've been in firearms for 8.
Do you have any special education or training that qualifies you for your position?
Yes, I have this glass bowl. I look into it, and then I lay out cards, and then I look at shell casings and make a guess. But I can't say that, so I will cotton candy words so it sounds like evidence. Yeah. Well, yeah.
I do.
And what is that?
I have a Bachelor of Science degree, which is a prerequisite to be hired as a forensic scientist at the crime lab. And then additionally, I completed the firearms and tool.
You're not a forensic science guy. You're a tool mark guy. Having a bachelor's in science and then you work with tool marks, it means you left science.
Mark examiner training program at the Wisconsin State Crime Laboratory.
And what does it mean to be a firearms and tool marks examiner?
There's a variety of things, tasks that I'm authorized to do with respect to casework, but the two primary components of my job include the function testing of firearms and the microscopic examinations of fired evidence.
As part of your duties, did you receive some firearms, cartridge casings, and bullets from the Racine County Sheriff's Office related to a case involving Allan Brown?
Yes,
Did you generate a report based on the items you received, the testing that you did, and the results?
Yeah.
Yes, I did.
If you were to see that report, would you
Yes.
recognize it?
I would.
Testimony. He really does. But he also made a horrific mistake that should have disqualified him at all. Yeah. Thank you. Noticed. I'm eating my chocolate. Meanwhile, I don't want that in the microphone.
Mr. Chairman, I'm showing you what's been marked Exhibit 22. Do you recognize that document?
Yes, I do.
What is that document?
This is the report I issued with respect to this case.
How can you tell?
My signature's on it.
It also has a case name associated with it, correct?
It does.
And what is the case name?
Allan M. Brown.
And your agency case number, correct?
The laboratory case number is R213137.
Now, in this report, it details items that you received, correct?
Correct.
Let's go through that. First, you received 3 firearms, correct?
That is correct.
What firearms did you receive for analysis?
I received 2 Glock Model 17 9mm caliber semi-automatic pistols and 1 Walther Model PP 32 automatic caliber semi-automatic pistol.
You also received a magazine associated with the Walther Model PP, correct?
Correct.
And did the magazine have any cartridges in it?
It did.
How many?
It had the magazine, which is sub-designated as part of the pistol. So originally they were in the same package, contained 5 unfired 32 automatic caliber cartridges.
You also received some fired 32 caliber cartridges, correct?
Correct.
How many did you receive?
3.
And then the rest of your report indicates cartridges and other rounds that you received related to the 9mm Glocks, correct?
Correct. The remainder of the evidence was 9mm caliber in class.
Now, as part of your duties, when you receive a firearm, what's the first thing you do with that firearm?
So the first thing we do is perform what's called a function test. The ultimate goal of the function test is for me as an examiner to determine whether
So sorry. I was looking into, since he said Walter, but I'm sure on day 1 they said Luger. I went quiet. Yeah, sorry. I said in a Walter PP from 1930 up to 1968 could fit in caliber .22, .25, .32, .380, and 18 millimeter. And feed system is 7 or 8 in the magazine. So I have to adjust my yes, thank you for correcting me. I will go back to watch on day 1 because I'm so sure they said Luger. But if he says Walter, and we will see the gun now, so I can compare. Yeah, it's still 1 in the pipe, 7 in the mag. If he had 22, it would fit 10 in the mag. But I will check that out more thorough later.
Whether or not the gun is safe to fire. By doing so, we conduct a physical and visual examination of the gun. We document make, model, serial number, all the pertinent characteristics of the gun, and then manually check any safeties it may or may not have. Has it been modified in any way? Is it broken or damaged in any way that would prevent us from being able to safely fire it at the laboratory? And once that is complete and we deem it's either safe to fire or not fire, we will then, if applicable, fire the gun and recover test-fired cartridge cases and bullets as applicable.
So focusing on the Walter model PP that you received, which in your report is designated item AM1, did you go through that process?
Yes, I did.
Did you deem whether the Walter model PP was functioning?
I did.
So if you could for the jury, what did you do with that Walter model PP to determine that it was functioning?
I test-fired it.
So you actually put a bullet in the gun and fire it?
Correct.
And then after test firing it and making sure that it's functioning, what is your next step in analyzing the evidence?
You come for the trials, you stay
Once
for the boomer.
firearms are test-fired and all of our documentation regarding them is complete and we've actually test-fired them, we recover test-fired cartridge cases and test-fired projectiles or bullets for the most part. Once that's complete, we're pretty much done with the firearms. We move into microscopic comparisons of fired evidence. So with respect to this case, we will document and microscopically compare all of the fired cartridge cases and fired bullets to determine if the group of just the evidence, how many guns they came from. Is there 1 gun, 2 guns? And then from there, we can compare the subsets of groups of evidence to specific guns where there's an agreement on class characteristics.
And did you do that in this case?
Yes, I did.
Were you able to determine if the 32 automatic caliber cartridge casings that you received came from that Walter model PP?
Yes, I was.
And did they?
Yes, they did.
And what you said microscopic examination, but how do you examine a cartridge to determine if it came from a particular weapon?
Well, now he goes into, I am unmuted. Yeah, had to check. This is standard, but the difference between this and the Murdoch trial is that they have the actual fired weapon, which makes this tiny bit more reliable, and but it's still junk science because, as he says, he only compares with that cartridges from that gun. That's it. He doesn't do blind test. There's no peer review. There's not an outsider who receives. This is a shell case we know is from the gun. Here you have 100 shell casings. Please find the one that match. Nothing of the sorts. He just fires. He has one. He fired 1 or 2, and then he compares until he finds something that match. It's bullshit science. Which I believe within a few years, this kind of evidence will be having the same fate as the polygraph and stuff like that. Yeah, it is confirmation bias science, also known as shit science. Yeah, 999 wasn't the best emergency number with the rotary phone. I had the Cobra phone where you had to pick it up It was in the bottom, and then you have to dial it like that. I heard it on they were speculating, talking about it during the Murdoch case in, if it was, I don't remember whose stream it was, but it is a few cases on the way up to the Supreme Court about this tool mark bullshit. Yep, there it is. United States v. McCluskey. Let's continue.
So I've used the phrase class characteristics a few times. What that means, class characteristics are broad, general terms used to describe make, model, serial number of guns, but with fired evidence components, it's what caliber are they, what shape is the cylinder, how much does the bullet weigh. Those are all class characteristics to help us sort groups of evidence. So for this case, I had a number of 9mm caliber cartridges and a number of 32 caliber cartridge cases. Those are obviously separate groups from each other based on class characteristics. They're plainly just different calibers. From there, we move into, once a group of evidence has agreement on class, everything visually has agreement, we move to microscopic comparisons. We use a tool called a comparison microscope. So it's basically any compound microscope you may have used in a college or high school science class, except there's two of them. And they're hooked together through a single eyepiece called an optical bridge.
Correct.
And that allows us to physically look at two items simultaneously at the same time in one field of view. And that's how we observe the individual characteristics that we're looking for. With respect to cartridge cases, there's a number of areas of interest. Plainly, anywhere the firearm, the internal components of the firearm come into contact with.
Your first phone had a flip and a pull-out antenna. That was the Ericsson. I only remember it being blue, and it on a later model you could flip it and you had one line of text, wasn't it?
With a piece of fired evidence, there's a transfer of individual characteristics. The areas that we're specifically looking for under the microscope are the firing pin impression, the breech face impression, extractor and ejector marks, chamber marks, and then with respect to bullets, we're looking at the rifling impressions of the projectiles themselves.
Officer upside down face. Does this change with a gun that is known for jamming? I don't know, or something of that sort. But they did not question it.
You just listed a lot of things you're looking for on the cartridges, on the cartridge casings. Could you go through those again and explain what they are? For instance, the breech face impression.
So an unfired piece of ammunition, an unfired bullet, if you will, has four primary components. The projectile itself and the case. The case is the metallic cylinder that holds gunpowder, and on the bottom of that is a primer.
I don't know if I'm flattered or offended. I'll go with flattered. Flattered, yeah.
The basic process of how a semi-automatic pistol is fired is that with every squeeze of the trigger, the firing pin strikes the primer. The primer is a small explosive that ignites the gunpowder. The gunpowder burns and pushes the projectile through the barrel. Simultaneously to that happening, if there are rounds left in the magazine of the gun, the cartridge case will be ejected and the gun will semi-automatically load the next round into the chamber until the magazine is empty. During that process, anywhere that the metallic structures of the gun come into contact with the cartridge case or the bullet, there's a transfer of tool marks. So each of the areas I mentioned are areas where there's a transfer of tool marks. So the breech is the back of the slide of the gun where the cartridge is chambered. And it's similar to hitting a nail with a hammer. The firing pin will strike the primer, and then the force of the explosion inside of the gun will push the cartridge case back against the breech of the gun, causing an impression. The firing pin impression itself, where the firing pin strikes the primer, is an impression. They're all different areas. I like to describe them as pieces of a pie. When examining cartridge cases, each area is a slice of the pie that we need to examine. And then when rendering an opinion on the source of the cartridge case, whether it's a firearm or a group of cartridge cases from one firearm, we have to account for the whole pie to make sure there's not a piece missing or something is wrong.
Now, you said you do this microscopic examination with 2 microscopes, correct?
2 stages of one microscope that we can see both stages simultaneously. So one eyepiece.
What pieces of evidence do you have on each microscope?
So the initial examination will be just the group of evidence to each other. And if there's agreement and consistencies in all the markings and all the individual characteristics that we're observing, we can conclude that a group of cartridge cases were fired in the same gun. And then ultimately, if we have guns to compare them to, on one side of the microscope will be evidence, and on the other side will be the test fire that we recovered from the gun when we shot it ourselves.
So in this case, you test fired the Walter PP, correct?
Correct.
Did you then compare the recovered cartridge from the test fire and compare it to 2 cartridges you received from the scene?
Ultimately, I compared the test fired cartridge cases to 3 total cartridge cases.
Okay. Were you able to determine whether they all came from the same weapon?
Yes. The 3 fired 32 automatic cartridge cases that I examined are designated at their laboratory as items D, AD, and AJ, were all fired in the Walther semi-automatic pistol.
If I were to show you the firearm and cartridges that you examined specifically related to the Walter PP, would you recognize them?
Yes, I would.
Yeah, probably on very, very possession of firearm or lesser crime that will never be appealed, where they were sentenced to a few years and then got out. Those will never be brought up again.
Do you recognize Exhibit 17?
Yes, I do.
What is that?
This is laboratory items AM1 and AM2. This is the Walther semi-automatic pistol, the magazine, and the unfired cartridges from the magazine, also including my test fires that I produced.
And how do you know that Exhibit 17 in your hand is item A1 and A2 from your report?
When an item of evidence is submitted to the crime laboratory, it's given an individual item number. We've been referring to these, but you can see that as a yellow barcode. So the barcode is the laboratory case number and the item number that we give that at the crime lab. Furthermore, in firearms, anytime
I would bet money on that this is the only Walter PP from the 1930s he have ever tested. And if there are no blind tests available, shouldn't be admissible.
time that we examine a gun, we will physically write with a Sharpie or paint marker the case number, our dates and initials on the gun itself, and that's might be tough to see, but it's silver. That's right there. So that's how I can recognize that this is the gun that I actually examined.
Now let's look at Exhibit 18. Do you recognize that item?
The next few minutes, if you're new to this and haven't heard it, pay attention.
Yes, I do.
And what is Exhibit 18?
This is a fired 32 caliber cartridge case.
And how can you tell?
So furthermore, firearms is generally speaking the last unit at the laboratory that will conduct any analysis. Any fingerprints or DNA or anything that needs to be done will be done prior to us ever receiving the item. So when we return evidence, when we're done in firearms, it generally will go back to the submitting agency in the condition that we leave it. So this packaging, as you see here, is how I physically packaged it. The original packaging as I received it is here. The item itself is at the top, which has the laboratory item number written on it with Sharpie. And the green marker that you can see on the heat seals is my date and initials from the day that I sealed the item.
And what item number is that cartridge?
Court exhibit number 18 is laboratory item AJ.
Okay, now let's look at Exhibit 20. Do you recognize that item?
Yes, I do.
And what is that item?
This is a fired 32 auto caliber cartridge case.
If you could look at the packaging, is that the packaging from that 32 caliber?
No.
And then if you could look at, compare that to Exhibit 19, what is the packaging in Exhibit 19?
Exhibit 19 is the packaging for the fired cartridge case.
Did you hear that? He put the evidence into the wrong evidence bags. And we are supposed to trust this guy looking at tool marks. This is called breaching the line of evidence, or something of that sort. At the moment he got the evidence, to the moment and forward, anything that passed through him should have been inadmissible, in my opinion. Because if you are this sloppy with evidence, how can we trust you with evidence? Now they explain it. It makes sense. This is not how evidence should be treated. Anything he touched in this investigation should be inadmissible, because this shows he's sloppy with evidence. And no objections from the defense. So this can't be brought up in appeal. Well, they can, but the appellate court will say, you didn't object. They didn't even brought it up in closing. My hope here is that, hope, but if the jury picks this up and says, wait a minute, breaking the chain of custody of evidence. Yeah. Anything that passed him should be inadmissible in this trial. He broke the chain of custody of evidence. There's no way around it, in my opinion. No way. I don't care how good the explanation is. Chain of custody of evidence, if it's broken, it's broken. I don't care how you explain it away. Once it's broken, it's broken.
How did that happen?
When we work a case, especially a case of this volume, we have all of our items.
Volume, there are, you have the guy, you have the car, you have the content, you have a minuscule amount of shell casings. There's no volume. There is no volume.
Of evidence in trays, and then we keep all of the original packaging, which is, if you imagine, dozens of paper bags in a pistol box similar to this. When I sealed them, I just flip-flopped the original packaging.
So that was a mistake you made?
Correct.
I'm not sure how to interpret this, because did he say that they take the evidence out of the bag? All the evidence out of all bags? Is that what he said? Is that a way to interpret this? And then he just flip-flopped and got the wrong bag. It's a breach in chain of custody of evidence. And if this was done with more evidence, all of it should have been thrown out.
Is the packaging from item 19, I'm sorry, strike that. Is the packaging from item 20 associated with the loose bullet in item 19?
Yes.
So what happened is basically you accidentally flip-flopped the packaging from items 19 and 20.
Correct.
How do you prove it didn't happen with other evidence? And there's a bit more to this. Yeah.
Item 19, the loose bullet, is an item that you examined in this case, correct?
Correct.
It just has nothing to do with the .32 caliber.
Correct.
Yeah.
What type of bullet is in item 19?
It's an unfired 9mm caliber cartridge.
Also an item you examined, correct?
Correct.
So going to the actual item in Exhibit 20, which item number is that in your report?
Court exhibit number 20 is item D, which is one of the fired .32 auto caliber cartridges.
And how do you know that?
So based on my experience and looking at the item, I can determine it's a fired cartridge case of the correct caliber, and also the item number, or we refer to them as numbers, but letter D is written in marker on the item itself.
Let's listen to that again.
So based on my experience and looking at the item, I can determine it's a fired cartridge case of the correct caliber, and also the item number, or we refer to them as numbers, but letter D is written in marker on the item itself.
So
You wrote with marker on evidence. How are these evidence now supposed to be re-examined? Well, you can say, well, they can always check other areas. I don't care. You wrote with marker on the actual evidence. Now, if that had been a gun or big piece of machinery, this is on a cartridge. I'm not sure if this is normal in the States to write on the actual evidence on cartridges. Contaminated. Dr. Heinz Ermitten, welcome. Welcome to the chat. Not much. I can summarize this trial with the defense did a 32-second opening statement. They waited until witness number 3 before they asked, no, witness number 2, which they asked 1 question. Witness number 3, they asked 2 or 3 questions. Then on day 2, on the second to last witness, was the first time they made an objection. There are some inconsistencies in the testimonies, but there are a lot of evidence that supports a guilty verdict because the defense, in my opinion, did not do their job.
Regardless of the
This is the
packaging, you can
toolmark
identify that as item D from your report,
which
correct?
we are rewatching
Is
because
that the
we
same with
are
number
on verdict
Court Exhibit 18?
watch.
Is AJ written on that caliber, or that cartridge? I apologize.
Correct.
Why do you write on the cartridge?
So based on your training, experience, and your examination, you can say that items A, J, and D.
Yes, find Dr. Heinz Ermitten on YouTube and subscribe to his channel. He does great stuff. Okay.
B, otherwise known as Court Exhibit 18 and 20, came from that gun in front of you, Exhibit 17.
Correct.
Is there any possibility that those cartridges came from one of the 9mm firearms?
No.
Why not?
There's a number of reasons, but the most simplest reason is the individual markings that we look at are individual to a specific gun. So during the manufacturing process, guns are imbued with individual characteristics because we're talking about a
there's
chunk
someone
of
at
metal
my door,
that is produced
so
into a firearm.
have
And
fun
during that
listening to
production
this guy.
process, there are microscopic markings as a result of the process.
Don't curse too
Milling
much
marks, drilling
in
marks,
the chat,
ringing,
and be nice
all of those
to
are
each other.
mechanical
Okay?
machining processes used to produce a
See you in
firearm.
a bit.
It's those marks that are transferred to the fired evidence during the firing process. Because I was able to identify the group of cartridge cases to the gun, that basically excludes all other guns. There's also a practical nature that 32 caliber is smaller than 9mm. So if you attempted to fire a 32 auto out of a 9mm, it physically would slide right through the barrel of the gun.
All right, thank you. I don't have any more questions.
Any cross-examination?
Just briefly,
Go ahead.
Mr. Chadwick, when you receive the items of evidence, do you also receive where they were located from the scene?
Potentially, but that's not information that I solicit.
Okay, in terms of items D, AD, and AJ, were you told where those items came from in the crime scene?
When items of evidence are submitted at the crime laboratory, anything that's on the packaging, the property numbers and any case information from the law enforcement is documented by the staff at the crime lab who receives that, and a receipt is produced as an exchange or an acknowledgement that the items were submitted. And I have access to that, but that's not something I regularly look at.
Did you look at it in this case?
I don't recall.
Okay, so you don't know where items D, AD, or AJ came from?
Correct.
Okay, no further questions.
Anything on those questions?
No.
Right, you're excused. Thank you.
Your Honor, I move Exhibit 22 into evidence, the report.
22 is received. All right, our next witness.
State calls Dr. Jennifer Herring, number 10.
No, it was just a neighbor. Sorry. Go to heaven, you angel, but you know what I mean. Okay. Yeah, but there's a series of charges, and then he probably will be extradited to Illinois to stand trial for. For alleged double homicide. That case, if he is convicted here, will be a lot easier for the prosecution in Illinois. Because then, if he is found guilty here, they can say, look at this. Yeah. I will see if I can go back and find. We don't have to listen to this guy. Let's watch me instead. Ta-da! Watch me looking for This one.
To figure out what to do next. And then finally, how he tries to run.
Oh, sorry. This is from day one. This is for Dr. Hines. The defense opening statement.
Out of his room into a fire escape hallway. He doesn't make it
This
very
is
far.
the last of the
Deputies
prosecution's
take him into
opening
custody again
statement.
immediately. So that's the last portion you'll hear. As I
No,
said
they're not
before,
taking
you'll
it.
see body cameras, surveillance video. You'll hear from crime lab experts. At the end of all this, there will be no question in your mind
Yeah.
of what the defendant did. That is the beauty of technology and body cameras. You will see it from 10 different angles, and there will be no question left in your mind that the defendant recklessly endangered the safety of Deputies Avila, Coltrip, and Tift when he fired a shot at them, that he caused injury and struck Canine Riggs, knowing full well he was a law enforcement dog, that he failed to comply with officers' attempt to take him into custody by trying to, that he possessed that as he to escape at the end of all counts.
Go ahead. Thank you. Who's doing the defense's opening?
It'll be me.
Go ahead.
Thank you.
Yes, fondle the microphone.
Ladies and gentlemen of the jury, as the state mentioned, you're going to hear a lot of evidence and you're going to see a lot of video footage during the course of this trial. All I ask is that you keep an open mind, use your own eyes and ears to determine what happened in this case, and most importantly, I ask that you hold the state to their burden of proof to prove each element of each charge against Mr. Brown beyond a reasonable doubt. I'll be back after all the evidence has been presented, and I will ask that you return a verdict of not guilty. Thank you.
That was it. That's the entirety of the defense opening statement. But it's logical, since they chose not to put on a case in chief. It's logical because they asked in total in 2 days maybe 30 or 35 questions and objected only once. So it's logical to leave this opening statement. Yeah, but that to me shows me that they gave up beforehand, which is odd because apparently the defendant, Allan Brown, turned down a plea deal before the trial. Well, the closing argument was on shooting towards the cops. That was the only thing they brought up in the defense closing. Didn't object to shooting the dog. Didn't object to, not object, but didn't bring up shooting the dog. Didn't bring up the supposed trying to flee in the closing argument. Only 3 of the 9 charges. That's the only thing they brought up in the closing argument. To me, I'm amazed. because let's see if we find, let me show you. One thing, let's see if we see it. No. The prosecution claims that when Allan Brown was in jail, not at the hospital, being treated for his wounds, at one point he was not shackled to the bed because they were transporting him. They claim he launched at the door, almost knocking this woman aside, but the only reason he didn't get past the door to his hospital room was because she clinged around his waist. I would say I would be amazed because let's see if we can see her stand up at any point. No, they didn't catch this girl go on the stand or off the stand. But I would argue 5'2", 5'3", 5'4", tops. 120. I can't see, unless she has some amazing skills in hanging around his waist, that she would be anything else but a flag wimping after him while he ran. She's not a large woman, but and we didn't, oddly enough, there was no test because they claimed there were two guards, her and a guy. They didn't bring the guy there to testify. I don't know why. Maybe they thought it was enough with her testifying, that they wanted to have the trial done in 2 days. But if I was on a jury watching this 5'4" tops woman, 120 pounds, claiming she stopped 5'9", 5'10" defendant. Wonder if I can find that. Yeah, found it. Stop screen. Share screen. Window. Yeah. 5'9", 185 pounds. Trying to flee. But she latched on to his waist, and that made him not pass the door. I have a hard time buying that. Yeah, maybe. And her testimony was, let's get rid of that. Let's see if we can find it again. There she is.
In open court.
Thank you. Deputy, what are your responsibilities when you're on guard assignment, particularly at a hospital?
My assignment would include pretty much watching the inmate, making sure that they don't assault hospital staff and that they don't escape.
Did you have any knowledge of this particular inmate before you were assigned to guard him?
Yes, ma'am, I did.
And what knowledge was that?
Prior to me guarding Mr. Brown, I was told that he was a suspect in 2 homicides in Chicago, that he had gotten in an officer-involved shooting with Kenosha County deputies, and that he had shot their canine.
Did you also receive any cautionary instructions from your supervision regarding Mr. Brown?
I did. I was
Boomer moment number 17 this stream. As I was saying back here behind the muted wall, female guard by herself, no. Female guard in a pair, maybe. In a group, they can have they can have a soothing effect. May have a soothing effect in a jacked up situation. I bet you had a hard time. Glad you went away from it, I guess. I don't know. Where was I? Absolutely not. I will not stop eating chocolate. Yeah, soothing effect if there's a lot of testosterone going on and stuff like that. But by yourself, no. And this is a violent criminal who tried to escape from prisoners. And somehow, while they were getting him ready to be transported, he was unshackled from the bed. Yeah.
told to use extreme caution with Mr. Brown because he was target glancing deputies' weapons as well as exits.
Objection. That would be. Damn. Speculation. She cannot know what's going on in the defendant's mind.
And for us lay people who may not know, what does target glancing mean?
So in law enforcement, we are taught to look for specific, I mean, I guess it's really a form of nonverbal communication. They're called pre-attack indicators is what we refer to them in law enforcement. Target glancing would be a form of a pre-attack indicator, meaning that an attack may be pending.
May be pending. Speculation. If you're walking around shackled, what are you supposed to do? Just look down? Oh, no, of course you. What's going on here? It's like being in church. You can't just stare at the priest. You look out, watch the ceiling, check out the window, look at your feet.
So when it's pretty much the theory of someone's eyes will, when they're thinking of an object, so if someone's thinking of my gun, they'll look down at my gun. Or if they're thinking of exit routes, they're going to be looking at door.
Yeah, I guess he lost 20 pounds in jail.
Doorways.
You began guarding Mr. Brown at around 10 a.m. that day, correct?
Yes, ma'am.
As you were guarding Mr. Brown, did you yourself see him target glancing?
Yes, ma'am, I did.
Objection,
Tell me about
speculation.
that. What did you see?
Multiple times when I was in contact with Mr. Brown, I could see him target glancing my weapons on my duty belt. He'd even asked me about the weapons on my duty belt.
Objection, speculation.
At one point, medical staff had asked us to get
Objection,
Mr. Brown
hearsay.
up onto his feet, so we were walking on the hallway for medical purposes. He was walking with a walker. I could see him target glancing a stairwell, which would have been to our left. Mr. Brown was fixated on that stairwell.
Let's talk about first him target
Objection,
glancing your weapon. You said he
speculation.
asked about it.
Yes, I recall him asking about our weapons, yes.
Do you remember specifically what he said?
I don't remember the specific questions, no.
Did you answer those questions?
No, I did not.
Now the hallway incident with the target glancing, you said he was using a walker, correct?
Yes, ma'am.
Was he handcuffed or shackled in any way?
He was wearing leg restraints.
And what are those?
So it's pretty much a chain. So they look like handcuffs. It's just a longer chain. And then they go around the person's feet.
And you said you saw him fixated on a stairwell, correct?
Yes, ma'am.
What did you do in response to seeing that?
I had told the nurse to stop. We were going to turn around because it was making me uncomfortable. He was still fixated on that stairwell.
And when you saw that, were you approaching the stairwell?
Yes, we were.
So you had them turn around prematurely. Would that be fair? Before you got to the stairwell?
Yeah, that's fair.
Objection. The prosecution is testifying.
When Mr. Brown was in his hospital room, how would he be restrained, if at all?
We kept Mr. Brown in those leg restraints, and then we also kept one of his arms also in a handcuff that was restrained to the hospital bed.
At one point, did Mr. Brown ask to sit in a chair?
Yes, he did.
Tell me about that.
So at one point, he had asked to sit in a chair that was located, it was like the right side of his bed. He had actually gone to sit in that chair. I told him, no, you can't sit there. Get back in your bed because we can't restrain you into that chair. And he had suggested that my partner and I restrain him to a table that was connected to that chair. I told him, no, we're not going to do that. Get back into your bed. I restrained him back to the bed. And then...
Hold on.
bed because we can't restrain you into that chair. And he had suggested that my partner and I restrain him to a table that was connected to that chair. I told him, no, we're not going to do that. Get back into your bed.
Get back into the bed.
Restrained him back to the bed.
Restrained him back to the bed. So he was unrestrained just by leg shackles out of bed. Who did the unshackling from the bed?
And then shortly after, my partner went to assess a similar chair that was in another room, which he said all Mr. Brown would have.
The male guard left the female guard alone in the room with a supposed violent suspect to look for another chair.
Had to do was lift the table in order to escape.
So if you had put him in that chair and handcuffed him to that table, all he would have had to do was lift the table and he would have been unhandcuffed?
Exactly. There he had an opportunity. He was only in his leg restraint. The male guard was out of the room. We don't know how close they were. He could easily just punched her out, and he didn't. Yeah, without him trying to escape. If we stretch our imagination, wild speculation. Did they want him to try to escape? That's wildly speculation from my side.
To the table?
Yes.
Okay. Now, on October 29th, 2021, at approximately 3:14 p.m., did you receive information from Mr. Brown's doctor that he was medically cleared?
Yes, ma'am.
And what does that mean to you as a law enforcement officer?
That means as soon as I get his discharge paperwork, I can bring him back to jail.
Did you receive his discharge paper shortly after that?
Yes.
And upon receiving the discharge paperwork, was Mr. Brown changed his clothes in any way?
Yes.
Do you remember what he was changed into?
I believe he was given a pair of pants.
So out of the hospital garb and into some other types of clothing for discharge?
Yes.
As he was changing, how was his...
That's how short or this officer or guard is. She has to get herself up on the chair from time to time. Is she even 5 feet tall? With plenty of opportunities to knock her out, take the keys, unlock himself. And he chose not to.
restraint situation?
We kept one of his hands restrained to the hospital bed as he was pulling up the pants.
And did he have leg shackles on at that point?
No, we had to take those off so he could get the pants on.
And then after he was changed to the pants, did you re-secure those shackles?
Yes, ma'am, we did.
Shortly after that, you began prepping him for transport, correct?
Yes.
And what does it mean to transport someone or prep someone for transport?
So typically we would, if it's in the inmate type setting, they're already in custody, we're going to transport them in belly chains and ankle restraints. So we're going to keep those ankle restraints on. And then I guess belly chains, it's a more comfortable solution than to be handcuffed behind the back. So you wrap the restraints around the belly, it's attached by a chain, and then there's essentially 2 handcuffs at the front.
So you were getting ready to put him in those so you could transport him to the jail, correct?
Yes, ma'am.
While you were doing that, Mr. Brown was in the hospital bed, correct?
He was in the hospital bed, yes, and then he stood up.
Okay, so tell me about that. He stood up from the bed?
Yes. So as I walked in with chains, and trying to figure out the chain situation, Mr. Brown had, without prompt, stood up from his hospital bed without us asking him to do so.
And what did he do then?
It appeared as if he was just tying his pants.
Okay. And then what happened next?
I then saw Mr. Brown, he started to lunge forward. I thought he was actually lunging at me. So I remember putting my hand up, and then he started to pass.
Let's go back a bit.
Mr. Brown had, without prompt, stood up from his
was in the hospital bed, correct? While you were doing, you put him in those so you could transport him to the jail, correct?
Yes, ma'am.
While you were doing that, Mr. Brown was in the hospital bed, correct?
He was in the hospital bed, yes, and then he stood up.
Okay, so tell me about that. He stood up from the bed?
Yes. So as I walked in with chains, and trying to figure out the chain situation, Mr. Brown had, without prompt, stood up from his hospital bed without us asking him to do so.
And what did he do then?
It appeared as if he was just tying his pants.
Do you know what's missing from this? Who unshackled him from the bed? If she is walking in with a belt with chains, isn't he supposed to be shackled to the bed? I'm not sure. Let's go back again.
in those so you could transport him to the jail, correct?
Wrap the restraints around the belly. We're going to keep those ankle restraints on. And then I guess belly chains, it's a more comfortable solution than to be handcuffed behind the back. So you wrap the restraints around the belly, it's attached by a chain, and then there's essentially 2 handcuffs at the front.
So you were getting ready to put him in those so you could transport him to the jail, correct?
Yes, ma'am.
While you were doing that, Mr. Brown was in the hospital bed, correct?
He was in the hospital bed, yes, and then he stood up.
I'm missing out where I hear you, Fire Red, but I don't see. Well, let's continue, because he was in the bed. He jumps out of the bed, unprompted, without them asking to, tying his pants together. Who unshackled him? In this situation where they are changing his shackles from the bed to this, they keep him shackled to put the belt on. They put the unfree arm in the shackle. Then they free him from the bed and put the shackle on. Alternatively, have the shackle from the bed on until the other shackle, the belt shackle, is on, and then take that off.
Okay, so tell me about that. He stood up from the bed?
Yes, so as I walked in with chains,
As I walked in with chains.
and trying to figure out the chain situation, Mr. Brown had, without prompt, stood up from his hospital bed without us asking him to do so.
And what did he do then?
It appeared as if he was just tying his pants.
Okay. And then what happened next?
I then saw Mr. Brown, he started to lunge forward. I thought he was actually lunging at me.
Who unshackled him from the bed? I can't hear. She collected the belt with the shackle thingy, went into the room. He stood up, tied his pants, lunged forward. Who unshackled him from the bed? That must have been the other guard. Why did he do that? Why isn't he testifying?
Me. So I remember putting like my hand up, and then he started to pass to my left. As he did that, he made contact with my left arm, and like shoved my left arm. So I went to the right slightly, and then he proceeded to run past me. And then I realized at that point he's trying to escape. He's trying to run. So I turned around.
And crime.
And as he was in the doorway, I was able to get my arms around his torso, and then use my body weight to bring him to the ground.
So at this time, how is his shackle situation if he's able to try and run out of the room?
So he's still in leg restraints at this point. His hands are free. He does not have handcuffs on.
So you indicate he.
I agree. One can still tie a drawstring cuff to a bed. Here she says his hands are free. Who uncuffed him from the bed? According to her testimony, she was outside, walking in with the restraints. He stood up, tied his pants, and launched forward. Who unshackled him from the bed? Has to have been the other guard. A breach of procedure. Why? It's good that you question me, Fire Red. Keep doing that, please, to keep us all, because I don't want this to be an echo chamber.
Made it to the door of the hospital room, correct?
Yes.
Did he turn as if he was going to run in either direction out of the room?
It appears as if he was going right.
What was to the right of the hospital
Objection,
room?
speculation.
So if you're inside the hospital room looking to the right, that doorway with the stairwell was out there.
Also, at what side was the door? Was it slightly opened? Because if it was slightly opened, so he could only pass to the right, then he leans to the right. That was earlier in the testimony. They claim that they allowed him to put his pants on. Then he was shackled to the bed. They took off the leg shackles so he could put them on with one hand because the other one was shackled. I have a cat visitor again. Wasn't you outside? Who let you in? Did I let you in? Probably. Must have snuck in while I was at the door.
The one you saw him glancing at earlier that day, correct?
Yes.
So you wrap yourself around Mr. Brown and gain control of him?
Yes.
And how do you do that?
Once we were onto the ground,
Didn't you skip one part there? Once we were on the ground. How? Let's go back a bit.
there.
The one you saw him glancing at earlier that day, correct?
Yes.
So you wrap
was
yourself
standing up,
around Mr. Brown
towards the door.
and gain control of him?
Yes.
And how do you do that?
Once we were onto the ground,
That's not a question. Once we were on the ground, no. The question was, how did you launch onto him?
I gained control of, I took like a front mount position. So I was on top of him. And then I gained control of one of his arms. By then my partner had already drawn taser. He was giving him, he was providing taser coverage and providing verbal commands, telling him to roll on his stomach and get his hands behind his back. So I was able to help assist to roll Mr. Brown onto his stomach, and then eventually was able to gain control of both hands.
This might be me going back and forward in her testimony. That might confuse things. We'll go her testimony from start to finish, so we get her entire narrative.
And then restrained him in handcuffs.
What did you do with Mr. Brown then?
We helped assist him to his feet and then put him in a wheelchair. And then I had medical staff assess him for any further injury.
Where was this?
Yeah, according to me, she skips a lot of parts. There, ow, damn cat. My legs are in danger because we have a cat here. Let's go back so we get her entire narrative. So we are not confused about the timeline.
As close as you can to the microphone. Spell your first and last name for the reporter.
And I will try to throw my cat out.
First name is Jamie,
without,
last name is Gill, B-E-A-L-L.
Blood loss.
Go ahead, counsel.
Thank you. How are you employed?
I'm a sheriff's deputy with the Racine County Sheriff's Office.
How long have you been a law enforcement officer?
I was hired in September 2019.
What are your current duties?
I'm currently assigned to the patrol unit.
And what does that mean? What type of things do you do as a patrol officer?
Well, I guess my particular assignment is the strategic patrol unit. So my job is interdiction, usually within the interstate area.
I want to draw your attention to October 29th of 2021. Were you on duty that day?
Yes, ma'am, I was.
Where were you assigned to that day?
I was assigned a hospital guard at St. Cat's in Pleasant Prairie, Wisconsin.
Who were you guarding at St. Cat's?
Allan Brown.
Do you see Mr. Brown in court today?
I do, yes.
Can you describe where he is seated and what he is wearing?
He's seated to my left in a gray shirt with a multicolored tie.
All right, the witness has identified the defendant in open court.
Thank you. Deputy, what are your responsibilities when you're on guard assignment, particularly at a hospital?
My assignment would include pretty much watching the inmate, making sure that they don't assault hospital staff and that they don't escape.
Did you have any knowledge of this particular inmate before you were assigned to guard him?
Yes, ma'am, I did.
And what knowledge was that?
Prior to me guarding Mr. Brown, I was told that he was a suspect in 2 homicides in Chicago, that he had gotten in an officer-involved shooting with Kenosha County deputy.
Objection. Outside of the scope, those allegations are not proven. Everything objection. But this is after the Chicago cops testified without interruption, so here we are. Sorry.
Deputies and that he had shot their canine.
Did you also receive any cautionary instructions from your supervision regarding Mr. Brown?
I did. I was told to use extreme caution with Mr. Brown because he was target glancing deputies' weapons as well as exits.
And for us lay people who may not know, what does target glancing mean?
So in law enforcement, we are taught to look for specific, I mean, I guess it's really a form of nonverbal communication. They're called pre-attack indicators is what we refer to them in law enforcement. Target glancing would be a form of a pre-attack indicator, meaning that an attack may be pending. So when it's pretty much the theory of someone's eyes will, when they're thinking of an object, so if someone's thinking of my gun, they'll look down at my gun. Or if they're thinking of exit routes, they're going to be looking at doorways.
You began guarding Mr. Brown at around 10 a.m. that day, correct?
Yes, ma'am.
As you were guarding Mr. Brown, did you yourself see him target glancing?
Yes, ma'am, I did.
Tell me about that. What did you see?
Multiple times when I was in contact with Mr. Brown, I could see him target glancing my weapons on my duty belt. He'd even asked me about the weapons on my duty belt. At one point, medical staff had asked us to get Mr. Brown up onto his feet, so we were walking on the hallway for medical purposes. He was walking with a walker. I could see him target glancing a stairwell, which would have been to our left. Mr. Brown was fixated on that stairwell.
Let's talk about first him target glancing your weapon. You said he asked about it.
Yes, I recall him asking about our weapons, yes.
Do you remember specifically what he said?
I don't remember the specific questions, no.
Did you answer those questions?
No, I did not.
Now the hallway incident with the target glancing, you said he was using a walker, correct?
Yes, ma'am.
Was he handcuffed or shackled in any way?
He was wearing leg restraints.
And what are those?
So it's pretty much a chain. So they look like handcuffs. It's just a longer chain. And then they go around the person's feet.
And you said you saw him fixated on a stairwell, correct?
Yes, ma'am.
What did you do in response to seeing that?
I had told the nurse to stop. We were going to turn around because it was making me uncomfortable. He was so fixated on that stairwell.
And when you saw that, were you approaching the stairwell?
Yes, we were.
So you had them turn around prematurely. Would that be fair? Before you got to the stairwell?
Yeah, that's fair.
When Mr. Brown was in his hospital room, how would he be restrained, if at all?
We kept Mr. Brown in those leg restraints, and then we also kept one of his arms also in a handcuff that was restrained to the hospital bed.
At one point, did Mr. Brown ask to sit in a chair?
Yes, he did.
Tell me about that.
So at one point, he'd asked to sit in a chair that was located, it was like the right side of his bed. He'd actually gone to sit in that chair. I told him, no, you can't sit there. Get back in your bed because we can't restrain you into that chair. And he had suggested that my partner and I restrain him to a table that was connected to that chair. I told him, no, we're not going to do that. Get back into your bed. I restrained him back to the bed. And then shortly after, my partner went to assess a similar chair that was in another room, which he said all Mr. Brown would have had to do was lift the table in order to escape.
So if you had put him in that chair and handcuffed him to that table, all he would have had to do was lift the table and he would have been unhandcuffed to the table?
Yes.
Okay.
But again, you were there alone with him while he wasn't shackled to the bed. And he did nothing.
Now, on October 29th, 2021, at approximately 3:14 p.m., did you receive information from Mr. Brown's doctor that he was medically cleared?
Yes, ma'am.
And what does that mean to you as a law enforcement officer?
That means as soon as I get his discharge paperwork, I can bring him back to jail.
Did you receive his discharge paper shortly after that?
Yes.
And upon receiving the discharge paperwork, was Mr. Brown changed his clothes in any way?
Yes.
Do you remember what he was changed into?
I believe he was given a pair of pants.
So out of the hospital garb and into some other types of clothing for discharge?
Yes.
As he was changing, how was his restraint situation?
We kept one of his hands restrained to the hospital bed as he was pulling up the pants.
And did he have leg shackles on at that point?
No, we had to take those off so he could get the pants on.
And then after he was changed to the pants, did you re-secure those shackles?
Yes, ma'am, we did.
Shortly after that, you began prepping him for transport, correct?
Yes.
And what does it mean to transport someone or prep someone for transport?
So typically we would, if it's in the inmate type setting, they're already in custody, we're going to transport them in belly chains and ankle restraints. So we're going to keep those ankle restraints on. And then I guess belly chains, it's a more comfortable solution than to be handcuffed behind the back. So you wrap the restraints around the belly, it's attached by a chain, and then there's essentially 2 handcuffs at the front.
So you were getting ready to put him in those so you could transport him to the jail, correct?
Yes, ma'am.
While you were doing that, Mr. Brown was in the hospital bed, correct?
He was in the hospital bed, yes, and then he stood up.
Okay, so tell me about that. He stood up from the bed?
Yes, so as I walked in with chains, and trying to figure out the chain situation, Mr. Brown had, without prompt, stood up from his hospital bed without us asking him to do so.
And what did he do then?
It appeared as if he was just tying his pants.
Okay. And then what happened next?
I then saw Mr. Brown, he started to lunge forward. I thought he was actually lunging at me. So I remember putting like my hand up, and then he started to pass to my left. As he did that, he made contact with my left arm and shoved my left arm. So I went to the right slightly. And then he proceeded to run past me. And then I realized at that point, he's trying to escape. He's trying to run. So I turned around. And as he was in the doorway, I was able to get my arms around his torso. And then I used my body weight to bring him to the ground.
So at this time, how is his shackle situation if he's able to try and run out of the room?
So he's still in leg restraints at this point. His hands are free. He does not have handcuffs on.
So you indicate he made it to the door of the hospital room, correct?
Yes.
Did he turn as if he was going to run in either direction out of the room?
It appears as if he was going right.
What was to the right of the hospital room?
So if you're inside the hospital room looking to the right, that doorway with the stairwell was out there.
The one you saw him glancing at earlier that day, correct?
Yes.
So you wrap yourself around Mr. Brown and gain control of him?
Yes.
And how do you do that?
Once we were onto the ground, I gained control of, I took like a front mount position. So I was on top of him. And then I gained control of one of his arms. By then my partner had already drawn taser. He was giving him, he was providing taser coverage and providing verbal commands, telling him to roll on his stomach and get his hands behind his back. So I was able to help assist to roll Mr. Brown onto his stomach, and then eventually was able to gain control of both hands and then restrained him in handcuffs.
What did you do with Mr. Brown then?
We helped assist him to his feet and then put him in a wheelchair, and then I had medical staff assess him for any further injury.
Where was this wheelchair located?
It was off to the, so again, looking in the hospital room, the wheelchair was off to the left of the doorway.
Hospital staff assessed Mr. Brown, you said, did they find any further injuries?
No.
At some point, did Mr. Brown make any statements to you about his attempted escape?
Yes, he said he wasn't trying to escape. He was just trying to get to the wheelchair.
The wheelchair, however, was to the left, correct?
Yes.
And it appeared to you that he was trying to get to the right, correct?
Correct.
At the time of all this, what type of uniform, if anything, were you wearing at the time?
I was wearing my full-blown sheriff's deputy uniform with a sheriff's badge on the front.
And when you first made contact with Mr. Brown, did you identify yourself as a law enforcement officer?
I don't remember.
And you said you had a partner with you, correct?
Yes.
What was your partner's name?
Deputy Hollyfield.
What was Deputy Hollyfield wearing?
He was wearing the same uniform I was with the sheriff's star on the front.
Did Mr. Brown ask you any other questions or say anything else about the attempted escape?
I don't recall.
Did he ask you if you were hurt?
Yes, he did ask me that.
At any point, did you give Mr. Brown permission to run out of that room?
No, I did not.
And he was in your custody at that time, correct?
Yes, he was.
Thank you. I have no further questions.
Any cross?
Officer, Mr. Brown never made it out of the hospital room.
Oop. They are back. They are back. I have sound on. Sound is not on law and C word stream. Yeah, I will be shocked if he's not found guilty on all counts. Yeah, I will not be taking bets. Now, it might be just that they have a question, but with every cop on their feet smiling, yeah, I don't think they are there for, oh, the jury has a question. Oh, yeah, poll. How? I have to go. Poll is up. Yeah, I'm on the first attempt. Yes, please like, subscribe, check out my other content. Because I have a great chat because of my hair. I don't know. If you find anything that you like, press like. Sound is on. If they only had a question, I'm going to laugh out loud. Hello, can we park here?
Please rise for the jury.
It is a verdict.
May take your seats.
All right, we're going on the record on Allan M. Brown, 21 CF 1344. Let's have the appearances, please.
Good afternoon. State appears by Alexander Smathers.
Allan Brown, appears in person with attorney Addison Kuhn.
Good afternoon. I'll ask the jury foreperson, do we have a verdict?
We do.
Can you hand all the paperwork to the bailiff?
2 hours plus lunch. With lunch.
All right, I'm going to read each count into the record. State of Wisconsin versus Allan Brown, 21 CF 1344, verdict form. Count 1. We, the jury, find a defendant, Allan M. Brown, guilty of first-degree reckless endangering safety. As to 1, Avelia is charged in count 1 of the information. Please answer the following question. Did the defendant use a dangerous weapon in committing this crime? Answer yes. Dated as 30th day of March 2023, signed by the foreperson. Verdict form as to count 2. We, the jury, find a defendant, Allan M. Brown, guilty of first-degree reckless endangering safety. As to Colin Coltrip, is charged in count 2 of the information. Please answer the following question. Did the defendant use a dangerous weapon in committing this crime? Answer yes. Dated as 30th day of March 2023, signed by the foreperson. Verdict form as to count 3. We, the jury, find a defendant, Allan M. Brown, guilty of first-degree reckless endangering safety. As to Terry Tiff, is charged in count 3 of the information. Please answer the following question. Did the defendant use a dangerous weapon in committing this crime? Answer, yes. Dated this 30th day of March 2023, signed by the foreperson. Verdict form as to count 4. We, the jury, find the defendant Allan M. Brown guilty of possession of a firearm as charged in count 4 of the as to count 5. We, the jury, find the defendant Allan M. Brown guilty of harassment of a police animal as charged in count 5 of the information. Dated as 30th day of March 2023, signed by the foreperson. Verdict form as to count 6. We, the jury, find the defendant Allan M. Brown guilty of mistreating an animal as charged in count 6 of the information. Please answer the following questions. Did the defendant cause injury to the animal and know that the animal was used by a law enforcement agency to perform agency functions or duties? Answer, yes. Question, did the defendant use a dangerous weapon in committing this crime? Answer, yes. Dated as 30th day of March 2023, signed by the foreperson. Verdict form, count 7. We, the jury, find the defendant Allan M. Brown guilty of failure to comply with an officer's attempt to take a person into custody as charged in count 7 of the information. Dated this 30th day of March 2023, signed by the foreperson. Verdict form, count 8. We, the jury, find the defendant Allan M. Brown guilty of driving or operating a vehicle without owner's consent as charged in count 8 of the information. Please answer the following question. Did the defendant possess a dangerous weapon while committing this crime? Answer, yes. Dated as 30th day of March 2023. Verdict form, count 9. We, the jury, find the defendant Allan M. Brown guilty of attempted escape from custody as charged in count 9 of the information. Dated this 30th day of March 2023, signed by the foreperson. The defense wish have the court poll the jury.
Yes, please.
Right. What this means, folks, I'm going to ask you individually, and I'm just going to use numbers. I'll start out way in the back, closest to the door. You'll be number 1. I'll go through here 6. I'll come back. You'll be 7, and I'll go through 12. I have 9 verdicts. They all have answers to them. They all have verdicts to say guilty. They all have the answers to the questions that says yes. So I'll ask juror number 1, is this your verdict on all these verdicts as to Mr. Allan? Juror number 2, are these all your verdicts as to Mr. Allan? Juror number 3, are these all your verdicts as to Mr. Allan? Juror number 4, are these all your verdicts as to Mr. Allan? Juror number 5, are these all your verdicts as to Mr. Allan? Juror number 6, are these all your verdicts as to Mr. Allan? I'll go to the front. Juror number 7, are these all your verdicts as to Mr. Allan? Yes. Juror number 8, are these all your verdicts as to Mr. Allan? Juror number 9, are these all your verdicts as to Mr. Allan? Yes. Juror number 11, are these all your verdicts? No, I'm sorry. Juror number 10, are these all your verdicts as to Mr. Allan? Yes. Juror number 11, are these all your verdicts as to Mr. Allan? Yes. Juror number 12, are these all your verdicts as to Mr. Allan? So everyone in this jury, I'll ask you one more time, are these all your verdicts? Yes. All right, everybody answered yes for the record. Okay, I did poll the jury. You are excused then, folks. Thank you for your service. Don't forget your personal belongings. I thank you for everything. Have a good afternoon, okay? If you need anything, you can talk to the bailiff.
Well, not surprised. Now, we have all been nitpicking on what we or I would have done if I was the defense.
All right, the jury is outside of the courtroom. Is there a motion by the state?
But
Yes, Your Honor, I move for judgment on the verdicts as well as revocation
shows
of any bond.
Guilt.
All right, as to judgment on the verdicts,
Given
there are 9
everything we
counts here.
discussed,
They're all guilty counts, so there'll be
were
a
to
judgment
be
on all the verdicts with the
tossed out.
enhance your
most of it
questions are
wouldn't have
in the
been.
verdict. The court's
It was
also, based
more
on the
than enough
charges and the convictions here,
for a jury to
going to
reach a
revoke the
guilty verdict.
defendant's bond and set the matter for sentencing and order a pre-sentence investigation. I will have the clerk give you a date and let me know if the date will work.
May 19th at 10:30.
Yeah, this will just be
good for the state.
That will, now it's just details. And well, I agree, Amanda. This was from A to Z, going through the motions. And as I said, even if we were nitpicking, bringing in stuff, should have said that, objective there, most of what we have been discussing would probably been in this trial anyway. Now, most said that Mr. Brown did what he was alleged to do. Most was also, I believe most, if not all of us, can see how they reached a guilty verdict. Now, it is appalling to me how the defense chose to conduct themselves. Yeah, but it was not surprising. Now he will be sentenced, and then there will be a trial in Illinois for double murder, and this will be fully brought up in that trial. But I will put up a link because I have been invited to another stream. It is the brother of Zachariah Anderson, who is currently being interviewed at MLS Law Show. So I will be directing you over there. I don't have a direct link, so you will have to do with this. And I will pin it. There. This was and the poll was 97% guilty and 3% not guilty. There's always one. But here we are. Thank you for showing up. Thank you for listening to me. Thank you for following this trial with me. Hopefully we have all learned a bit from this. And we might see each other over either on Saturday, where I will have a stream going through my 5 top arguments from the Zachariah Anderson trial. But go over there, like MLS, his channel, subscribe to it if you find his channel interesting. But this will be it for me for today. You all have a nice day. Talk to you later.